Good morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. Let's start in Lake County, Ohio. Judge Vincent Collada. Let's see what's going on there.
50, 25 CR 001570, 25 CR 001571, 25 CR 001572, and 25 CR 001573. In the 1450 case, there was a two-count information filed. I apologize. The defendant is present at open court today with his counsel, William Watson. In the 1450 case, a two-count information was filed on November 3rd of 2025. Those counts being grand theft of a motor vehicle, felony of the fourth degree, and theft of felony of the fifth degree. In the 1570 case, a two-count information was filed on November 10th of 2025. Those two counts being grand theft of a motor vehicle, felony of the fourth degree, and misuse of credit cards, felony of the fifth degree. In 1571, there was a one-count information filed on November 10th of 2025, that count being grand theft of a motor vehicle, felony of the fourth degree. In 1572, a one-count information was filed on November 10th of 2025, that count being grand theft of a motor vehicle, felony of the fourth degree. And in 1573, a one-count information was filed on November 13th of 2025, that count being grand theft of a motor vehicle, felony of the fourth degree. It's the state's understanding today that the defendant will waive his right to indictment in all 5 cases, that he will plead guilty to each count and each of the informations, that we will ask to defer sentencing so that a pre-sentence report, psychological evaluation, and victim impact statements may be ordered. There's no sentencing agreement. The 4 cases in the 1500s are all secret information, so they do have an additional document for booking.
Which ones are those?
1570, 1571, 1572, and 1573.
Well, aside from 1450.
Yeah, 1450 is the only one that was a bind over. They're all informations, but the 1500
So why weren't these all just done one information? Why weren't these just done in one information?
They came in at different times, as well as they came in from different departments.
They're all filed at the same time.
There are 3 different file dates for the informations.
Like, how long apart?
The first one was November 3rd. The last one was November 13th. Since he was in jail, the initial one as well was a time concern. There's no sentencing agreement.
Mr. Watson, is that all accurate?
Thank you, Your Honor. May it please the court, that is my understanding of this morning's hearing. I have had ample opportunity to discuss all of these cases with Mr. Hudson as they came in. He has indicated to me that he is prepared to enter a change of plea by way of information as just outlined by the state. First, Your Honor, for each respective case, my client does understand that by entering a plea by way of information, he is going to be waiving his right to have these respective cases presented to the Lake County Grand Jury. Furthermore, for all the cases, my client understands that by entering a change of plea, he will be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor.
Thank you. You said there were secret informations?
Yes, the 1570, 71, 72.
But then how were they bound over?
No, 1450 was the only one bound over.
So the other ones didn't get bound over?
Correct. I believe I said 1450 was bound
Right.
over. So he was in jail.
So the other ones just were sent, police reports that were sent to your office directly?
Yes, as they came in. They did not all come in on the same dates.
They all came in within 10 days of each other?
Because the state contacted the police departments to have them sent over as secrets to try and get them as close in time as possible.
Mr. Hudson, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this morning?
Yes, sir.
They've indicated to the court they believe it's your desire in each of these 5 cases to waive your right to have the case presented to a grand jury, and I'm going to explain in a moment in more detail what that actually means. And then you're going to plead guilty to the charges in each of the respective informations, and I'll go over each of those with you to make sure you understand what those are as well. We would then, if I accept your plea, defer or continue the sentencing to a future day, get some evaluations completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do here today regarding these 5 cases?
Yes, sir.
Well, before I can accept your guilty plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, all the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
I got you.
All right. Let's get started then. How old are you, sir?
22, sir.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that, or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No, sir.
Not even prescribed medication, nothing?
No, sir.
Now, did you receive a copy of each of these informations before you came in here today?
Yes, sir.
And you had a chance to look those over at some point?
Yes, I did.
Now, we'll start with 25 CR 1450. I'm charged with 2 counts. Pleading guilty to both of these counts. And what's alleged in count 1 is on or about September 29th, 2025 in Willoughby Lake County, Ohio, that you did with purpose to deprive Robin Bostic, who was the owner of property, being a Chevy Impala, that you knowingly obtained or exerted control over that property without the consent of Robin Bostic, who again was the owner, or any other person authorized to give consent. The property involved is a motor vehicle, which makes the offense grand theft of a motor vehicle a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, I do.
Any questions about it?
No, sir.
Count 2, what's alleged is on that same day, September 29th, 2025, in Willoughby Lake County, Ohio, that you did with purpose to deprive Anthony Tortorici, the owner of property, being a Fifth Third bank card, that you knowingly obtained or exerted control over that property without the consent of the owner or anyone else authorized to give consent. It's further alleged the property involved in the theft is a credit card, which makes the offense theft a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, sir.
Any questions about that?
No, sir.
Now, in case 25 CR 1570, again, you're charged with 2 counts. What's alleged in the first count is on or about October 1st, 2025, in McNally County, Ohio, that you did with purpose to deprive Ashley Carney, the owner of property, being a 2024 Black Dodge Ram, knowingly obtained or exerted control over that property without the consent of Ashley Carney, who again was the owner, or anyone else authorized to give consent. The property involved is a motor vehicle, which makes the offense grand theft of a motor vehicle a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, sir.
Any questions about it?
No.
Count 2, what's alleged is on or between October 1st and October 2nd of 2025 as a part of a continuing course of criminal conduct beginning in Willoughby Lake County, Ohio, and ending in Euclid, Cuyahoga County, Ohio, that you did with purpose to defraud obtain property or services by use of a credit card in one or more transactions, knowing or having reasonable cause to believe that the card had been expired or been revoked or was obtained, is being retained, or was being used in violation of the law. It's further alleged the cumulative retail value of the property and services involved in one or more of the violations, which involved one or more credit card accounts and occurred within a period of 90 consecutive days, was over $1,000, which makes the offense of misuse of a credit card a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes, I do.
Any questions about it?
No, sir.
In case 25 CR 1571, there's one count here, and what's alleged here and what you're admitting to is on or about September 20th, 2025 in Willoughby Hills, Lake County, Ohio, that you did with purpose to deprive Davon Boyd, the owner of property, being a 2017 Black Dodge Ram Rebel, knowingly obtain or exert control over that property without the consent of Mr. Boyd, who is the owner, or anyone else authorized to give consent. The property was a motor vehicle, which makes the offense grand theft of a motor vehicle a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes, sir.
Any questions
No,
about
sir.
it? In case 25 CR 1572, again, it's one count. It's alleged here that on or about August 2nd, 2025, in Wickliffe, Lake County, Ohio, that you did with purpose to deprive Joseph Costello, the owner of property, being a 2022 white Subaru Ascent, knowingly obtain or exert control over that property without the consent of Joseph Costello, who is the owner, or anyone else authorized to give consent. The property involved is a motor vehicle, which makes the offense grand theft of a motor vehicle a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, sir.
Lastly, in case 25 CR 1573, that's one count. It's alleged here on or about August 31st, 2025 in Eastlake, Lake County, Ohio, that you did with purpose to deprive William Dolan, who is the owner of property, being a 2016 red GMC Canyon, knowingly obtain or exert control over that property without the consent of Mr. Dolan, who is the owner, or anyone else authorized to give consent. The property involved was a motor vehicle, which makes the offense grand theft of a motor vehicle a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes, sir.
Any questions for me?
No, sir.
So you understand the nature of the charges in all 5 of these cases?
Yes, I do.
Well, before I can accept your guilty plea, then I need to make sure you understand all the rights you're giving up by pleading guilty. And first of all, in each of these cases, you have the right to have each case presented to a grand jury. So the documents that I just read to you are called informations. And information is a criminal charge brought by the prosecutor's office without the case having previously been reviewed or considered by a grand jury. Excuse me. Now what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Everyone here in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. You have that right as well in each of these cases, but you can waive that right or give up that right if you desire and go forward on the charges brought by the prosecutor and the information, and your attorney has indicated he believes that's how you want to proceed. Is that correct?
Yes, sir.
Well, before I can accept or go any further, I need to have you acknowledge that here in open court in writing. And I have in my possession here 5 documents, each called a waiver of indictment. There's one for each respective case that we've talked about. And these documents set forth what I just explained to you about the grand jury process and that you want to give up that right. Before I can go further, I need to be assured you understand what these documents say, and you sign them here in open court. Now, they're each identical, except that they each have the respective charges that go along with that particular case. That could be the difference. Otherwise, they explain the same right. My understanding is that before I came out here, you had a chance to go over each of these documents with your lawyer. Is that correct?
Yes, sir.
Mr. Watson, is that accurate? Did you review each of these with Mr. Hudson, go over them with him, answer his questions?
Yes, Your Honor, I did review each waiver of indictment form individually with Mr. Hudson. I read it to him, he read along with me. He signed it, and I signed it in the presence of the prosecutor, Your Honor.
When he went through it, he indicated he understood them to you?
Yes, Your Honor.
Is that correct, Mr. Hudson?
Yes, sir.
So you understand what these documents say?
Yeah, I do.
Do you have any questions for me about them?
No, sir.
Now, it does appear, and your lawyer indicated that you signed them. Did you in fact sign them?
You said what?
Did you sign each of these
Yes, I
5
did.
documents?
Yep.
Ms. Cutch, you witnessed those signatures as well?
Yes, Your Honor.
All right, well, I will make each of these documents part of the record in each of the respective cases. At this point, Mr. Hudson, I'm going to review with you all the other rights you have that you're giving up by pleading guilty. And all these rights apply to each case. I'm not going to go over them 5 separate times. All the rights you're talking about you have for each of these cases. If there's anything that applies to 1 or more cases and not all the cases, I don't think that should be the case here, but I'll make sure I point that out otherwise. Otherwise, everything applies to all 5 of the cases, all right?
Sounds good.
All right, well, in each of these cases, you have the right to have a trial. A trial could be to me as a judge, or I listen to all the evidence and I make the decision whether you're guilty or not guilty. But you also have a constitutional right in each of these cases to have a jury trial, and that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be unanimous. Unanimous means that all 12 of them would have to agree together, one way or the other, guilty or not guilty, as to each individual charge. You understand that?
Yes, sir.
You understand by pleading guilty, you're giving up your right to have a trial in this case?
Yes, sir.
Now, if we had a trial in any of these cases, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation to prove you guilty at a trial before you could ever be found guilty. You're presumed innocent of all these charges. The presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. You understand that?
Yes, sir. My contact.
You all right? You need a Kleenex or something? Give him a tissue stand, please.
Contact expired. I'm all good.
You all right? Were you able to hear what I was just saying, or?
No, can you say it again,
Let me
please?
go over that one again. I noticed that your eye was bothering me. What I had said was that if we do have a trial, the prosecutor is going to represent the state in that trial.
Okay.
And she would have what we call the burden of proof. Having the burden of proof means that it's her job, her responsibility, that she bears the burden to prove you guilty before you can be found guilty. And what that means is you're presumed innocent of all the charges, and the presumption of innocence remains and stays with you until the state, if at all, was ever able at a trial to overcome the presumption of innocence and prove you guilty. Do you understand that?
Yes, sir.
Now, when I talk about this burden of proof, since these are criminal charges, that burden is what we refer to as proof beyond a reasonable doubt. It's the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state has to present at a trial to prove you guilty. Right?
Yes, sir.
In each of these cases, the state would have to present evidence to prove each element or each part of the charges I just read to you beyond any reasonable doubt before you could ever be found guilty of any. Sorry?
No, sir.
I wasn't asking you a question.
Oh,
I was
okay.
explaining to you. What I'm saying is that
Okay.
at a trial, the state would have to present evidence to prove each element or each part of each of these charges beyond any reasonable doubt before you could ever be found guilty. Do you understand that?
Yes, sir.
So do you understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes. Yes.
Now, in order to try to do that, if we did have a trial in any of these cases, the state would be bringing witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. That's called cross-examination. He could ask them, anything he wanted to within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, I do, sir.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, I do.
And you further can request this court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if there was anyone out there that wasn't willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you have a constitutional right not to testify if you don't want to. That's a decision. That would be a choice that you would have to make. Do you understand that?
Yes.
And since that's solely your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here, she's not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Further understand that if we went to trial and you were found guilty of any of these charges, you'd have the right to appeal or challenge that guilty finding to another court, a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted. Excuse me. Or any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, sir.
All right, well, do you have any questions at all about any of these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
You still want to plead guilty?
Yes, sir.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is you're going to be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty to, well, let's start with 25-1450. You're pleading guilty to 2 charges. The grand theft of a motor vehicle is a felony of the 4th degree. That carries with it a possible term in prison of a minimum of 6 months, maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, sir.
Count 2 is the theft charge. That carries with it a possible term in prison of a minimum of 6 months, maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes, sir.
Now, since there are 2 separate charges here, if I impose a prison term, I would impose a prison term on each count. Then as the judge, I have the discretion to run those prison terms either concurrent or consecutive. Concurrent means together at the same time. You serve the sentences at the same time. Consecutive is the opposite, one after the other. You serve the prison term on the first count, whatever it is, complete it, then serve the prison term on the next count. You understand the difference there?
Yes, sir.
So in this particular case, 25-1450, if I impose the maximum sentence on each count and ran them consecutive, you're looking at a maximum possible prison term of 30 months or 2.5 years in prison. You understand that?
Yes, sir.
Now in case 25 CR 1570, also 2 charges. The first count's the theft of a motor vehicle, a felony of 4th degree. Again, that's a 6 to 18 months in prison potentially. Count 2 is a felony of 5th degree. It's the misuse of credit cards, 6 to 12 months. Same thing with this case. I can run them if I impose a prison sentence concurrent or consecutive. If I gave the maximum sentence in each count consecutive, it would be 30 months in prison for this case. Do you understand that?
Yes, I do.
25 CR 1571. In each of the remaining cases, 1571, 72, and 73, it's 1 count. They're all grand theft of a motor vehicle. Each of these are punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. You understand that?
Yes.
So the maximum prison term on each of these last 3 cases is 18 months in prison. You understand that?
Yes, sir.
Now, as I explained a moment ago, the 2 cases that had multiple charges, I could run the prison terms consecutive in each of those. At the time of sentencing, if I impose a prison term in each of these cases, I could run the prison term in each case concurrent or consecutive to each other as well. Do you understand that?
Yes, sir.
So I'm required to make sure you understand the maximum sentence you face here today by pleading guilty to all these charges. My math is correct. If I give you the maximum sentence in each of these cases and run them all consecutive, you're looking at 5 years, 9.5 years in prison. You understand that?
You said 9.5? I think you said 4.
First 2 cases were 30 months each. That's 5 years.
So there's a 4
And the other
and a 5
2 is
year, 4 and a
year and a half, year and a half, year and a half.
These are all 4s.
Okay.
So this is technically 4.5 for those 3, and then that's
To be 114 months.
2.5 and 2.5 here, so that's 5. Plus 4.5 is 9.5 technically.
For sure. I'm just saying.
But that's, in theory, that's what he could do. He's asking if you understand.
I understand.
That's if I gave you the maximum sentence in every count you pled guilty to and ran everything consecutive. The maximum sentence you face would be 9.5 years. Do you understand that?
Yes, sir.
Are you currently on probation or parole to any of the courts or agencies or any type of supervision?
Yes, sir. Cuyahoga County.
For what?
For the same thing. F4. I got an F4 theft.
Were you on probation when any of this happened?
Yes, sir.
I need to advise you that there may be consequences in that court. Is that the only court or anywhere else?
Oh, you said what?
Is that the only court or anywhere else?
Yes, sir. That's only court.
There may be consequences in that court with that judge for committing a new crime while on probation. If you commit a crime while on probation, it could be a probation violation. Nothing I can do about it or I'm going to do about it, but there could be consequences in that court there. Do you understand that?
Yes,
I need
sir.
to make sure you understand that.
Yes, I do.
Do you have any other charges pending against you anywhere?
Yes, I'm trying to think. Yeah, I do.
In Lake County or somewhere else?
No, I think somewhere else.
Sir?
Cuyahoga County, and I think Summit.
Summit? Oh, yeah, Portage County. I have an M3 pending.
The only reason I bring that up, and I don't know if it'll be applicable here or not, but if you're not currently serving a prison term, are you?
No, I'm not.
If you get sentenced to prison in another court before you're sentenced here, and if I impose a prison term, I can run a concurrent or consecutive to that. But it already has to be imposed. If you're not going to leave here before that and go somewhere else, then that's probably not going to be an issue. If you've been sentenced to a prison term prior to being sentenced here, I can run a prison term concurrent or consecutive to that. But again, it has to be imposed. I can't run a prison term consecutive to some future possible unknown prison sentence. I can't say, if you get prison in Cuyahoga, then mine's consecutive. I can't do that. It's already got to be imposed. You understand that?
Yes, sir.
Right. Now, for each of these 5 cases, if a prison sentence is imposed in any of them, you could be placed upon your release from prison on what's called post-release control. It's sometimes called parole. It's a period of supervision you would be on after you completed the prison sentence. And for each of these cases, it could be up to 2 years. You understand that?
Yes, sir.
And if you are on post-release control for any of these cases and you ever violated any of the rules of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Excuse me, say what?
I'll say that again. If you are on post-release control and you violate any of their rules of supervision, the parole authority can send you back to prison as punishment for violating their rules. And it could be up to 9 months in prison for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term I impose is.
Okay, I understand.
Okay. Now, aside from the possible prison sentence I just explained, there's other sanctions that could be ordered. You could be fined in each of these cases. In 25 CR 1450, the grand theft of a motor vehicle carries with it a possible fine of up to $5,000. The theft of the credit card involves, a possible fine of $2,500. So altogether, in this case, $7,500 possible fine. No fines are mandatory. You understand that?
I understand, sir.
In the other case, 1570, that is the 2 counts also. The grand theft of a motor vehicle is punishable by a possible $5,000 fine. Misuse of a credit card is $2,500. Again, maximum fine in that case is $7,500. Do you understand that?
Yes, sir.
In the remaining 3 counts, they each have 1 count of grand theft of a motor vehicle. Each of those are punishable with a possible fine of $5,000 each. Do you understand that?
Yes.
So altogether, with each of the 5 cases, a possible maximum fine of $30,000. Do you understand that?
Yes, sir.
You could also be, you could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable in any of these cases. Do you understand that?
I understand.
Also, you could be ordered to pay restitution to any victim for any economic loss any victim may have suffered as a result of the criminal conduct involved. Do you understand that?
Yes, I understand.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible in doing so because prison is not mandatory or required for any of these cases or charges. You are eligible in each case for probation or what's called community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't mean you'll automatically get probation? It means I'll consider that if that's what you're asking for. I'm going to look at all the information presented. Then I'll make the decision I think is the right thing to do. You understand that?
Yes, I understand, sir.
Now, if you are put on probation, it could be for up to 5 years of supervision. And as the judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions of probation can be in order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes, sir.
Further, if you are ever on probation to this court and you violate any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate or end your probation and send you to prison at that point. And if I did it then, again, it could be for the period of time in each case that I mentioned earlier, up to a maximum with all 5 cases of 9.5 years in prison. You understand that?
Yes, sir.
That could also be ordered to be served consecutive to any other prison sentence you may be serving at that time for any other case, or that you're being sentenced to if there's any new cases. You understand that?
Yes, I understand, sir.
Lastly, when we do come back here for sentencing, you're going to have the right at that time say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor here can also recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to go along and follow that if I didn't think that's the right thing to do. Do you understand that?
Yes, I understand, sir.
All right. Well, are there any questions for me about the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, I do.
You still want to plead guilty to these 5 cases?
Yes, sir.
Have you had enough time to talk about these cases with your lawyer and have him review everything with you, answer all your questions?
Excuse me?
Have you had enough time to go over everything with your lawyer, meet with him, talk with him, have him review everything with you, answer
Yes,
your
sir.
questions? Are you satisfied with his advice and counsel?
I am.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No, sir.
Have you been threatened or coerced by anyone to plead guilty?
No, sir.
Are you entering your guilty plea freely and voluntarily?
Yes, I am, sir.
All right then, Mr. Hudson, any questions for me at this time regarding anything we just talked about? What you're pleading guilty to in each case, the rights you're giving up, the penalties you face, any questions?
No, sir.
Do you need any more time to talk to your lawyer before we go forward with your guilty pleas?
No, sir.
All right, then what we're going to do at this time, the prosecutor is going to present me with the facts that she believes would be demonstrated at a trial if we had a trial. We'll do one case at a time. I want you to listen to what she says because then I'll have some follow-up questions for you, all right?
I understand.
So I'll leave it up to you to just say what case you're talking about first, and then we'll do one at a time.
Starting with 25 CR 001450.
All right, this is the chart case with one count of theft of a car and one count of theft of a credit card, Mr. Hudson. Go ahead.
Yes. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on September 29th of 2025, initially just before 4 p.m., Willoughby Police Department responded to the Heinens located on Ridge Road in Willoughby, Lake County, Ohio for a theft report. Anthony Tortorici indicated that he works at Heinens, had left his wallet in his vehicle. When he came out, he found that his car door was open, his wallet was gone. He had also received a notification that his debit card had been used at a Walgreens for a purchase just under $40. Officers went to Walgreens, found out that a Visa gift card had been purchased. They were able to view the video to see the individual who was involved. Shortly after that, same day, approximately 4:45 p.m., Willoughby Police Department responded to the area behind the Night and Day Club on Euclid Avenue in Willoughby, Lake County, Ohio, for a theft of a motor vehicle. Robin Bostic indicated that her 2019 Chevrolet Impala had been stolen between approximately 4 and 4:40 p.m. She had parked it in that area. She had left her purse in the car, which did contain her keys. The car was gone when she came out. Through flock and video of businesses in the area, the individual who had taken the car was able to be seen in those videos. It was determined that both the credit card theft and the auto theft were the same defendant, who was later identified to be Sean Hudson, the defendant. On October 2nd of 2025, the Chevy Impala was recovered in Garfield Heights, where the driver and sole occupant of the vehicle was in fact the defendant, Sean Hudson. He also had in his possession Robin Bostic's credit cards as well as gift cards. When officers spoke with Mr. Hudson, he agreed he got the card from Willoughby and that he had bought a gift card at the Walgreens. All this occurring in Lake County within the state's business in that case.
Mr. Hudson, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show at a trial in case 25 CR 1450 if we did have a trial?
Yes.
What, if anything, you had to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, I did, sir.
Very well then, regarding count 1, charging you with grand theft of a motor vehicle, felony the 4th degree, what is your plea to that count?
Guilty.
Regarding theft, felony the 5th degree, this is count 2, what is your plea to that count?
Guilty.
All right, Ms. Putz, please move on to the next case.
In 25 CR 001570, had that matter proceeded to trial, the state would have proven beyond reasonable doubt that on October 1st of 2025, around 11:20 a.m., the Mentor Police Department was dispatched to a dental office on Mentor Avenue in McNally County, Ohio, for theft of a motor vehicle. They spoke with Ashley Carney, who indicated that she had arrived at work that morning in her black 2024 Ram 1500. She had parked it and rushed in, leaving her purse with her car keys in the vehicle. She received a text notification that her American Express card had been used at a Target in Willoughby in Lake County, Ohio. She went to check on her card. She saw that the truck was gone. In addition to the American Express card, there was also a Discover card and 2 different Visa cards. She was able to track the location of her vehicle to Glenville Avenue in Cleveland. The car was recovered in that location by the Cleveland Police Department. Ms. Carney learned that her 3 credit cards had been used at the Willoughby Target as well as the Euclid Marks and Euclid Walgreens, totaling almost $1,300 worth of items that she did not purchase and not give permission to purchase. Willoughby Police Department followed up with Target, getting the video, seeing the defendant, Sean Hudson, using the credit cards. When Willoughby was interviewing the defendant, he did admit to taking the Ram truck. You saw a picture of it identified as one he had taken, as well as the credit cards were in the car. All of this occurring in Lake County, Ohio, and that would have been the evidence in 1570.
Thank you. Mr. Hudson, were you able to hear what the prosecutor just had to say as to what she believes the evidence would establish in this case if we had a trial?
Yes, sir.
What, if anything, you have to say about these facts? Are they true? Did you do what she said?
Yes, I did, sir.
Very well. Regarding count 1, charging with grand theft of a motor vehicle, a felony in the 4th degree, what is your plea to that?
I plead guilty.
And regarding count 2, charging you with misuse of credit cards, a felony in the 5th degree, what is your plea to that?
Guilty.
All right.
In
Ms.
20
Cutts, next case.
In 25 CR 001571, when this matter proceeded to trial, the state was proven beyond reasonable doubt that on September 21st of 2025, around 2:45 p.m., the Willoughby Hills Police Department was dispatched to the lobby of 2260 Carr Lane, which is the Pine Ridge Apartments in Willoughby Hills, Lake County, Ohio, for a stolen vehicle report. They spoke with a Devon Boyd, who indicated that his 2017 black Dodge Ram Rebel had been parked in the parking lot. He had left it the day before. When he had come out that afternoon, the vehicle was gone. Looking at flock video, they were able to see the vehicle was taken approximately 4:54 p.m. on September 20th of 2025. On September 27th of 2025, Cleveland Police Department recovered the vehicle. Willoughby Hills Police Department detective went and spoke with Mr. Hudson, who indicated that he had in fact taken the vehicle from Pine Ridge Apartments. He had initially told Willoughby Police Department, who notified Willoughby Hills, who spoke with the defendant, Mr. Hudson, directly. He admitted to taking the vehicle. And that is all occurring in Lake County, Ohio, and that would be the evidence in 1571.
Mr. Hudson, were you able to hear what the prosecutor had to say regarding what she believes the evidence would establish in this case if we had a trial?
Oh, yes, sir.
What, if anything, you have to say about these facts as she presented them? Are they true? Did you do what she said?
Yes, I did, sir.
Very well, then regarding case 25 CR, it's 1571, correct?
Correct.
1571. Charging with grand theft of a motor vehicle, a felony of the 4th degree. What is your plea to that count?
Guilty.
All right, Ms. Cutts, the next case, please.
In 25 CR 001572, had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on August 2nd of 2025, around 9:50 a.m., Wickliffe Police Department officers responded to the Center for Pastoral Leadership on Euclid Avenue in Wickliffe, Lake County, Ohio, for report of a stolen vehicle. They spoke with Joseph Costello, who indicated that his white Subaru Ascent was missing from the parking lot where he had parked it. Again, block was reviewed to see whereabouts, as well as it was determined how to activate a tracking location system for the vehicle. It was found to be at 15620 Damon Avenue in Cleveland, Cuyahoga County. Officers went to that location, located the vehicle there. Swabs were taken. There was a Charger in the vehicle that was not the owner's, that was also swabbed. That came back to defendant Sean Hudson. On October 10th, 2025, Wickliffe Police Department detectives went and spoke with the defendant, who did admit, Sean Hudson, the defendant, did admit to stealing the Subaru, that he had parked it, and then later saw that the police were at it. He admitted the charging cord in the vehicle was in fact his. All this occurring in Lake County, and that was in the state's evidence in 1572.
Mr. Hudson, were you able to hear what the prosecutor had to say regarding what she believes the evidence
Yes, sir.
was established in this case if we had a trial?
Yes, sir.
What, if anything, good to say about these facts as she presented them? Are these facts true? Did you do what she said?
Yes, sir, I did.
Very well, then regarding count 1 in case 25 CR 1572, charging with grand theft of a motor vehicle, felony of the 4th degree. What is your plea to that count?
Plead guilty.
All right, last case, please, Ms. Cutts.
Thank you, Your Honor. In 25 CR 001573, had that matter gone to trial, the state would have proven beyond a reasonable doubt that on August 31st of 2025, shortly after 10 p.m., Eastlake Police Department officers responded to Arlo Precision at 1630 East 361st Street in Eastlake, Lake County, Ohio, for a report of a stolen vehicle. William Dolan indicated that he arrived at the location that evening at approximately 8 p.m. When he left around 10 p.m., was going to leave, his vehicle was gone. It's a red 2016 GMC Canyon truck. On September 1st of 2025, the vehicle was recovered in Akron. Inside the vehicle was a white phone charger that was not Mr. Dolan's. Swabs were taken of the vehicle and the charger. It came back to the defendant, Sean Hudson. When officers spoke with the defendant, specifically Willoughby Police Department, he did admit to taking the red GMC truck down the street from Target. All this occurring in Lake County, Ohio, within the state's evidence.
Mr. Hudson, could you hear just now what the prosecutor had to say? The facts would be in this case if we had a trial?
Yes, sir.
What, if anything, you have to say about these facts? Are they true? Did you do what she said?
Yes, I did, sir.
Regarding count 1, then, charging you with grand theft of a motor vehicle, felony of 4th degree, it's case 25 CR 1573. What is your plea to that count?
Guilty.
All right, in each of these cases, I have 5 separate documents called a written plea of guilty and judgment entry. Each of these documents set forth what I've just spent the time going over with you and reviewing with you, the rights you're giving up, the penalties you face, what you're actually pleading guilty to. Before I can accept your plea in any of these cases, I need to make sure you understand what these documents say and that you've signed them here in court. Now, they're all identical, again, except for the individual charges that go along with each particular case. Otherwise, they all say the same thing. And the penalties could be different for each case. Obviously, we've already gone over that. My understanding is before I walked out here, you had a chance to review each of these documents with Mr. Watson. Is that correct?
Yes, sir.
Mr. Watson, is that correct? Did you review these documents with your client? Read them to him, answer his questions?
Yes, Your Honor. So I did review each individual written plea of guilty form with my client. I read through it. He read along with me. He indicated he understood it. He signed them, and I signed them in the presence of the prosecutor, Your Honor.
Is that correct, Mr.
Yes, sir.
Hudson?
Yes, sir.
So you understand what these documents say?
Yes, sir.
Do you have any questions for me about any of them?
No, I do not, sir.
Now, your lawyer indicated, and it appears from looking at it, that you signed each of these documents. Did you in fact sign them all?
Yes, sir.
Ms. Cutts, you witnessed that too?
I did, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written pleas of guilty. Let the record reflect. The defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights in each of these cases. The court also finds the defendant understands the nature of each of the charges, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all of this to be knowing, intelligent, and voluntary, the court will accept the defendant's pleas of guilty in each case. And in case 25 CR 1450, I'll find the defendant guilty of count 1, grand theft of a motor vehicle, felony of 4th degree in violation of 2913.02A1, and count 2, theft of felony of the 5th degree in violation of 2913.02A1. In case 25 CR 1570, I'll accept the defendant's plea, find him guilty of count 1, grand theft of a motor vehicle, a felony of 4th degree, violation of 2913.02A1, as well as count 2, misuse of a credit card, a felony of the 5th degree, in violation of 2913.21B2. In cases 25 CR 1571, 1572, and 1573, I will also accept the defendant's guilty pleas. In each of those cases, I'll find him guilty of count 1 in each case. Each count is grand theft of a motor vehicle. They're each felonies of the 4th degree, and they're each in violation of 2913.02A1. In case 25 CR 1470, I'm going to continue defendant's bond of $50,000 cash surety. In the remaining counts of cases, I'm going to set bond in each of those cases at $5,000 cash surety. I'm going to order a pre-sentence report and investigation in each of the 5 cases, a victim impact statement in each of the 5 cases. Is there anything else you're requesting, Mr. Watson?
Your Honor, I believe it was brought up by the state, but if I believe a psychological evaluation might be appropriate, Your Honor.
And we'll do a psychological evaluation in each case as well. So, Mr. Hudson, I've referred you to the probation department so they can prepare some reports. The way they prepare the reports is they need to conduct some interviews with you beforehand. They'll bring you over, or they'll send you information, or come over and see you. I'm not exactly sure how they'll do it, but you'll be getting information or meet with them. It's important that when you meet with them and speak with them and fill out paperwork that you're open and honest with them, because they check and verify everything you tell them. And if they learn you're misleading them in any way, if you're not cooperative with them, they're going to let me know that, and I would obviously consider that as sentencing. You understand that?
Yes, sir.
All right, in each of the in four cases, 1570 through 73, I've also signed an order that the defendant get booked into the jail on each of these cases, so we'll send that order over to the jail so they can deal with that. I think that covers everything. Ms. Cutts, is there anything else?
No, thank you, Your Honor.
Mr. Watson?
Nothing further, Your Honor.
All right, thank you.
So nothing further. Is there anything else? That was almost a 45-minute hearing for that man's crimes. I think he stole everything in Lake County from the looks of it. Hi, Ellie. So Ellie is loving up on all of you. She's in a great mood this morning. She thinks you should go to courtroomfiles.com, by the way, where we currently have our Black Friday sale going on. If you are an everyday viewer, you get 15% off. There's a promo code there on the site. If you are a channel member, you get 25% off, and that goes for anything in the store right now, doesn't it, Ellie? You should also check out our 2026 TCF courtroom calendar. The theme is street justice, so check that out. We think it's super cool, and everybody should have one, including you. All right. Good morning once again. It's a beautiful Tuesday. Let's head up to Michigan and Judge Simpson. He's got a full house this morning. Let's see what's going on.
Please offense is asking
Okay.
for an
Well,
adjournment.
no, I'm not. I don't.
It's funny that Miss White is standing up there and not in the middle of the mess. Go ahead.
It's not
For
a
once,
mess.
I
For
know.
what?
For once.
I'm going to be asking for a preliminary examination, so I don't really need an adjournment. I just need the discovery.
Well, I don't set a preliminary examination until you have the discovery.
Okay, well, there you go. So I need an adjournment then.
Okay. Took us a while to get there, but we got there. You want the 4th or the 11th then?
Since the 4th is my birthday, I'm gonna take the 11th.
And I'll set it for the 4th. You know? December 11th, 2025, 9 a.m. Bond will continue.
And I would like to speak
And
to,
I would just wish you happy birthday, but now you're
Thank
gonna
you.
ruin that.
I like
Go
to
ahead.
speak to the matter of bond, Judge.
Yes, sir.
Your Honor, my client, is 26 years old, no prior history, no prior felonies. He's had one DUI that was like 7 years ago, and that is the only thing that is on his record. This incident stemmed from a matter that happened back in February, January. There was in Canton. This stems from a situation that happened in Canton. My client cooperated fully with the authorities back then. When I say fully, I mean fully. He resided at the same place that when he was arrested back in February, where he got arrested, when he was arrested a couple of weeks ago. In July, when he tried to get some of his phone, his laptop back from the authorities in July, the officer told him then that they were still trying to investigate and charge him with the crime. He still didn't try to flee I'm trying to get to the point that he knew that this something may be coming down the pike, but he still resided at the same location and didn't try to flee or anything. I believe the bond currently is $500,000, which might as well be $5 million. I would respectfully ask the court, based upon his non-criminal history and the fact that he did not try to flee, even though he was arrested back in February, was held for a few days. Is that correct? 3 days, fully cooperated with the authorities then, gave statements and everything. And a few months passed. And when he got his phone back or went to try to get his license from the police officers, the detective, they said, hey, we're still investigating. They're trying to charge you with this. Still resided at the same location. When they arrested him, he was at the same location. I would respectfully ask the court to give a more reasonable bond. I know the charges are serious. However, if Mr. Dabney would have wanted to flee, he could have done so for the past 7 months, Judge. He could be in Tahiti right now.
Does he have other felonies pending?
No, Judge.
No. Okay. Fine.
Your Honor, I would object. It's my understanding from Mr. Kennedy, as I'm covering this case from today, is that at the next PCC, it's our intention to amend the complaint to amend the charges and add charges of aggravated CSAM possession using a computer to commit a crime, as well as CSAM possession. In this case, it does stem from an incident in Canton where authorities were investigating a different individual. And in that investigation of that individual, they found a video on that individual's phone that had been produced in his basement with an individual on a video who resembles Mr. Alan Dabney sexually assaulting a child. Through that, they got his phone for this investigation and located an overwhelming amount of CSAM on his device.
On Mr.
Yes, and those images include images of children performing sex acts on each other, as well as being sexually assaulted by adults, as well as nude photos. And the report only just gives a small, preview of that. The report states overwhelming amount of CSAM on his device. So I have extreme concerns given that he was investigated for a video of him sexually assaulting a child, which then led to.
You honestly, now I like to hold on.
No,
She just indicated it
you
resembled.
need to not interrupt.
Okay.
She did not interrupt you.
She just.
No, what did I say?
I understand, Judge.
Go ahead, miss.
And then now they find all these other images and videos on his phone. So I have concerns, would ask that bond remain as set.
What I would like to object to was she indicated it resembles. They had 9 months to determine whether or not this was in fact that a person on the video. And now she's saying resembles. And then 2 minutes later, she said, it is him? I object to that mischaracterization, Judge.
And it was led to him, and then there's CSAM on his phone.
And just as I know it may not matter, but Mr. Alan Dabney was involved with this man in a romantic relationship, and this man that they found the devices, he had possession of his devices, of my client's devices. This Sharik Alam. This person stayed in Canton. The authorities was led to this other individual's location. My client was involved romantically with this person that they arrested and charged back in Canton in February. As I already indicated, I understand that the charges are serious, but what I really do not like is that when she says resembles, that means that they don't know if it's him or not. And for the past
Maybe
7 months,
that's the purpose of these proceedings.
I understand, but I don't like the fact that she said resembles and then says it's him.
That led to him, as I'm to understand, and that.
Yes, I'll correct what I said. If the report says resembles, we have to talk with Detective Morrison further to see what that video actually entailed, as it was just the first part of the report. So I'll correct what I originally stated. But that video did lead to them getting Mr. Alan Dabney's phone and locating voluminous amounts of CSAM on his device.
Anything further?
No, Judge. I just think that a more reasonable bond in this circumstance with no prior criminal history would be more like 100,000, 10%, Your Honor.
Well, given that if it was that individual, but then led to CSAM, which was on his device,
which was in the possession of his lover.
You want to? I'll let you go.
Oh, I'm sorry.
No, I'll let you go.
I don't have my robe on
No,
today.
I know you don't have one at all,
I'm
and maybe you got to figure out who does.
I understand. I'm sorry. Get a little excited.
Because this is going to be a long hearing.
No disrespect, Judge.
Well, it was.
Okay.
Given everything that the court has heard, and further that there are additional charges, which I understand are coming in the case, the court does believe that the bond as set is appropriate. Motion for bond reduction is denied. Bond will continue.
Thank you.
Your Honor, just briefly, may I just respectfully ask for the 10% or no?
Bond will continue as set. Thank you.
Thank you.
Happy Thanksgiving. Happy Thanksgiving. Remember, Thanksgiving. Here.
Oh, yes. Is that supposed to help? Hold on. Nope, doing nothing. Let's see what this puts. Court calls case People versus Gavin Porter.
Another order, Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. Paul Taylor appearing for defendant Gavin Albert Porter, who is standing at my right.
Your name, sir?
Gavin Porter, Your Honor.
I have before me a plea form that indicates, is that what we're doing?
Yes.
Yes, Your Honor.
Plea form indicates that the defendant would be pleading guilty to the charge of illegal transport of a firearm in a vehicle, the 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. There's further the agreement that the prosecutor will recommend a sentence of no additional upfront jail, and the sentencing judge waiver is, that's the court's full understanding of the agreement.
That's correct.
That's our understanding. Also,
Your Honor. Not transporting, but unauthorized.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Gavin Porter.
Thank you. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of illegal transport of a firearm in or upon a vehicle. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that, sir?
Yes, Your Honor.
All right. Still, and you also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty?
Yes, Your Honor.
On the date of September 19, 2025, at the location of 1620 East Medical Center Drive, City of Ann Arbor, Washtenaw County, State of Michigan, were you in a motor vehicle? Were you in a Chevy Silverado?
I own a Chevy Silverado. Yes, Your Honor.
I'm sorry to hear that, but were you in it? I'm a Ford guy, so I had to say it, but
I had my car valeted.
Pardon?
I had my car valeted that day. That was it was in the possession of the valet.
Okay. And in that vehicle, at some point you drove to the
Yes, Your
valet.
Honor. Yes, Your Honor.
Correct. All right. And in that vehicle, was there a pistol?
Yes, Your Honor.
And where was it located?
In my center console, Your Honor.
All right. And do you have authority to transport that weapon in that fashion?
No, Your Honor.
All right.
Not yet, Your Honor.
Pardon?
Not yet, anyways. I'm trying to get a class in.
Got it. Okay. But at the time you did
No,
not.
I did not.
All right. Sir, if I accept your plea, in this case, court does have to advise you if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, the court would no longer be bound by any recommendation or evaluation in your case, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
People are not, Your Honor.
No, Your Honor, we are not.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied, Your Honor.
Defendant is satisfied, Your Honor.
All right, court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
December 19th at 8:30 a.m.
Your Honor, if we may, could it please be pushed into January?
the court over there will be more than happy to do that, I think.
Okay.
Okay, that's the only date I have.
Yes.
That's the only date I have.
Okay. Thank you, Your Honor.
December 19th, 2025. What time?
8:30.
At 8:30. Bond in this matter will continue unless you want to make an argument. No, go ahead.
Thank you very much.
Thank you, sir. Have a good holiday.
Happy Thanksgiving.
Court does call the case. People versus Devon Galliard.
Alexander, on behalf of people.
And good morning, Your Honor. Attorney Maxwell Dubin, P number 86012, on behalf of Mr. Galliard.
Sir, can you state your name?
Devon Galliard.
Thank you. All right, what are we doing in this case?
Your Honor, today's the date and time set for PCC. I'm asking for an adjournment of the PCC, and then if I'm able to address bond, Your Honor.
Yeah. You want I can do December 4th or the 11th. He's in custody, so I'm going to go to the 4th. Probable cause conference, December 4th, 2025, 9 a.m. Esteban.
Your Honor, I believe this court may recall this case. At the last hearing, you revoked bond. My client was intending to, or was granted previously to go to Texas. He did not go to Texas. He returned to Georgia, subsequently revoking bond to a no bond warrant. I want this court to know first and foremost that my client is not here to make any excuses, reasons. He understands that when a court puts in an order, that order must be followed to a T. It doesn't matter what mistakes you make or what you think. Everything needs to be, every I needs to be dotted and every T needs to be crossed. Okay, Your Honor, that being said, I would point out that my client does not have a history, a criminal history whatsoever, pretty much and he's never been on a tether prior to this. He did make a mistake. He is owning up to that, Your Honor. What I'm asking here today is that this court either allow him a second chance to prove himself, and in the alternative, give him some type of attainable cash bond. When you did revoke bond, I know it's obviously court ordered. I will point out that my client immediately drove from Georgia, made arrangements, and turned himself in immediately, showing that he can abide by any rule sanction that this court puts upon him. Just to give some clarity, not as an excuse, the reason he did not return to Texas, Your Honor, is my client was in the military.
I lost you, counsel. I can't hear you.
Can you hear me now, Your Honor?
I can.
Which part did you lose me at?
I don't know because I didn't hear it.
Okay. Well, okay. Well, in short, Your Honor, just some background. Besides, my client does not have a criminal history. This is his first time dealing with something like this. He did not return to Texas, and this is not an excuse. He did not return to Texas. His intention was to. That being said, the military, which he was in prior, actually shipped his stuff to Georgia, to his mother's house. That was the reason he did go to Georgia and went to Georgia. What we're asking here today is an attainable cash bond and or a second chance to prove to you that he can abide by any rule sanction that you would put upon him, Your Honor.
Any response from the people?
Your Honor, at this point, I'm going to object. I don't know. I have concerns. I don't know exactly what he would be saying if he's released. I have concerns that he was given the chance to go to Texas. He told the court and people he was going to Texas. He didn't go to Texas. He went to North Carolina, South Carolina, Georgia, never went to Texas. And I have concerns that if he's released, he's just going to go wherever he wants. As he said last time during the hearing, that since he's on the tether, he could just go wherever he wanted. And then I have concerns given that he went to Georgia, and the argument was that if something came up for court, like an exam or a hearing, he had to attend in person, he would be there in person. He wasn't here last time in person. He was in Zoom. The only way we got him here in person was that he had to turn himself in on a no bond warrant. So I have concerns that this time I don't have enough information on where he'll be staying, what those terms of bond will look like when he gets out, because I don't know if he's going to try to go back to Georgia or if he's going to try to go back to Texas. I just don't know. So at this point, I'm going to object.
Anything else?
Yeah, if I may respond briefly, Your Honor, if my client is given bond, he will stay and remain in Georgia and even come back in person if
How do I
necessary.
know that?
Well, if I may, Your
because
Honor,
last time he told me he was going to reside in Texas, and I let him leave, and he never set foot in Texas.
and if I may just respond to how you would know that, Your Honor, besides the fact that he's on tether, he was very upfront with the tether, with probation. He didn't lie. He didn't try to say he was in Texas when he wasn't. He was very candid with them when they asked. And he knew he was being tracked and monitored, Your Honor. So his intention was not to deceive you in any way. But that being said, I and my client understands why the court did what they did in revoking his bond. I want this court to understand that my client is attempting to be very candid and upfront. He's not running away. And the reason, if I may respond to the prosecutor, that he appeared via Zoom is because he couldn't get here in time. So I had him log on because he didn't want to not appear at all. And then, of course, subsequently his bond was revoked and he immediately came back. He's not running from this, Your Honor.
At this point, the defendant's bond will continue as revoked. I let him leave. He told me where he was going. He's now trying to, and never went there. And now he's trying to tell me he's going to some other place. I have no idea. I can't believe this defendant. I can't trust that he's going to do what he says he's going to do. So the motion for bond reduction or bond in this case is denied. This matter is adjourned to December 4th. Thank you.
Thank you for hearing me out, Your Honor, and I hope you have a good rest of your day as always.
You do the same, sir.
It's a Tuesday. It's the Courtroom Files Live. Welcome, everybody. I know some of you are getting ready for travel, so safe travel to all of you. It's that time of year. Get to spend time with family, sometimes whether we like it or not, but I hope everybody has a good week here. We're going to continue with Judge Simpson. There's actually a decent riches of court this morning. There's a lot going on, but Judge Simpson's court has been interesting so far, so we'll hang here for a bit while longer.
These people have been out of control. No, it's been really bad. We'll talk. Court does call the case of the people versus Zipporah Morgan.
Good morning, Your Honor. Jonathan Sachs for Ms. Morgan, who is appearing via Zoom from Georgia. Supposed to be.
Is she really?
Yep. Ms. Morgan.
Did you see that last guy there? No kidding. Don't answer. Anyway. State your name, ma'am.
Zipporah Morgan.
Thank you. I have before me a plea form. Is that what we're doing?
It is, Your Honor. We have a negotiated plea worked out for a deferred sentence and a misdemeanor disposition.
The plea form indicates that the defendant will be pleading guilty to the charge of improper possession of a firearm in or upon a vehicle. The 90-day offense. Upon her successful plea to that charge, count one would be dismissed. There is a sentence agreement of a deferred sentence pursuant to 771.1. That's the court's full understanding of the agreement.
That's correct. That's correct, Your Honor. Thank you.
Ma'am, can you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name for the record, please. You muted.
Oh, Zipporah Morgan.
All right. You can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of improper possession of a firearm in or upon a motor vehicle. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that?
Yes, sir.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
Still wish to plead guilty?
Yes.
And to that charge, with particular attention to paragraph 5, those are your trial rights. You understand that you're waiving or giving up all of the rights that are contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
On October 26, 2025, at the location of 579 Eugene Street in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle or in a motor vehicle?
I was getting out of a motor vehicle, yes.
And in that motor vehicle, or while you were getting out on your person, was there a firearm?
Yes.
Was it yours?
Yes, sir.
And where was it located?
In the middle console of my car.
All right. Did you have authority to carry that weapon in that fashion?
No, I did not.
All right. Ma'am, if I accept your plea and you commit misconduct between the time of my acceptance of your plea and the time of sentencing, I do have to advise you that the court would no longer be bound by any evaluation or recommendation regarding your sentence, and you would not be entitled to withdraw your plea. You understand all of that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
I am not, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
You will satisfy, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered. Sentencing in this matter will be
January 15th at 10 a.m.
January 15th, 2025, 10 a.m. That is before Judge Washington. Bond in this matter will continue. Happy Thanksgiving. Thank you.
Thank you, sir. You too.
Happy Thanksgiving, Your Honor, to you and the court, to the prosecutors, and especially the public defenders.
Anybody else you want to bring into that? And happy Thanksgiving to you, counsel. Court does call the case People versus Robert Burnett.
Just spell this for people.
I'm going to interrupt this court for just a minute. So Michael and I and a couple other people, we've been talking in the chat about this whole gun possession thing in Michigan, and compared to Arizona, where Michael and I live, you know, Michael joked it's like a crime not to carry a gun here, where in Michigan, you know, you have to jump through all these hoops and everything else. So I was curious, and I pulled violent crime data for Michigan versus Arizona, because here in Arizona, we're all carrying all the time. It's just the facts. It's the way that it is. Where in Michigan, it's very hard to do it. So I was curious. This is 2024 data. This is violent crimes per 100,000 people. In Arizona, 422 per 100,000. In Michigan, 434. Murder and non-negligent manslaughter, both states are tied at 5 per 100,000. A certain kind of personal assault that I have to be careful what I say on YouTube these days. In Arizona, 40 per 100,000. In Michigan, 57. Because again, I've said this before in other places here on the channel, what happens when you have these overly restrictive laws with regards to self-defense is it hurts women the most. And we see that here. So those personal kind of assaults, way higher in Michigan. Robbery, interesting, a lot higher in Arizona. Though robbery isn't necessarily a face-to-face where you have to defend yourself. Aggravated assaults, however, Arizona 312 per 100,000, Michigan 341. So, do the restrictive gun laws necessarily keep people safer? At least that data would seem to say no, but feel free to discuss in the chat. Let's get back to Judge.
By which people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
People waive their right to a preliminary examination in both cases.
Yes, Your Honor.
Preliminary examination having been waived, defendant over to circuit court on the single count in each case.
Your Honor, we acknowledge receipt, waive formal reading, and stand mute, please.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pretrial will be set for
December 18th at 1:30 with Judge Slay.
December 18th, 2025, 1:30, Judge Slay.
And I think the court wanted me to add that GPS tether provision to the
one you submitted.
This is the waiver form.
Oh. Gave her back the one she did right. Is that?
No, you haven't.
1 for 2 is not bad.
December 23rd, 2023, 25.
December 18th.
December 18th. What did I say?
23rd.
That's because she kept messing me up. December 18th, 2025, 1:30 before Judge Slay. Bond in these matters will continue.
Okay.
Thank you. I don't know where it is. Court does call the case People versus Martina Smith.
Water Assistant Prosecuting Attorney for the People.
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Ms. Smith, who is present and approaching to my right.
Morning.
Morning, Mr. All right. What are we doing?
Your Honor, we are asking that this court set this matter out for a preliminary examination. I'm asking for some additional time, though I do have all discovery. There is a issue I need to follow up on, and it may lead to a better resolution for my client.
But as for the discovery you have from the people, you have that now.
Yes, what I need to follow up is not in possession of the government.
Got it. And how much more time, sir, would you need?
Probably a week, y'all. Extra week.
Setting these for the 9th, correct?
Yes.
I would be setting these for the 9th, so I've got the 16th, 23rd.
I'd ask for the 23rd. The 9th, I'm in a homicide trial in Ingham County.
23rd.
Yes, sir, please.
People have their witnesses available the 23rd.
We'll do our best.
Preliminary examination in person, December 23rd. 2025, 12 noon. That's before me. Bond. You'll continue. Thank you. Is that it for you, sir?
Yes, sir, it is, Your Honor. Thank you.
Please, on a separate matter.
Your Honor, is that before this court?
Yes,
Thank you.
before me. Mr. Jones, you can approach, please, on a separate matter.
All right, well, he brings somebody up to the bench. I do want to point out that today's program is sponsored by us, the Courtroom Files itself. We have a Black Friday sale going on, as you can see on your screen right now. Everybody gets 15% off. If you're a channel member, you get 25% off. That goes for everything that we sell, and we've got cool stuff. For whatever reason, though, I can't seem to scroll on this right now. Weird. I'll have to fix that. But one thing I do want to point out is our first ever wall calendar. This is for 2026. The theme of the calendar is street justice. We went with a graffiti look. Each month is themed to what the month brings. Like, for example, for January here, new docket, new drama, calling in the new year. But be sure to check that out. It's priced well, especially after the discounts. It's affordable for everybody. Every wall should have one. If you are at all a court junkie, you need to make that happen. And it's a great way to support the channel as well. Let's switch it up a little bit. This is about an hour into the Wayback Machine, but this was first appearances with Wade Mercer a little while ago.
Excuse me, Mr. Perkins, I'm seeing it at the same time because your cases are identical for first appearance purposes. What I mean is each of you are accused of violating the terms of your probation or community control, and in each case, the circuit judge assigned a no bond warrant. So what I want to do this morning is I want to go ahead and arraign you on these VOP cases and get you an attorney appointed if you're asking for one. Mr. Brand, would you like to have an attorney appointed to represent you?
Yes, sir.
Great. And Mr. Perkins, same question.
Yes, sir.
I'm going to appoint the public defender's office to represent both of you. Listen to Mr. McDaniel. He's going to give you a court date, and then we'll see if you have any questions in just a second. Mr. McDaniel.
Yeah, we're going to plead not guilty. Yes, to set this on January 8th pretrial docket, and I've asked the most spoke Mr. Green to come by and visit them prior to that hearing.
Mr. Mitchell, anything?
No, Your Honor.
So January 8th will be your arraignment date, or your not. You've already been arraigned. It'll be your court date in VOP court in front of Judge Garcia. Mr. Brand, do you have any questions?
No, sir.
Wish you the best, sir. Mr. Perkins, do you have any questions? No questions from him, Mr. McDaniel?
No, nothing, Your Honor.
Andrea Merchant. Merchant, good morning. Ms. Merchant, you're here for first appearance, ma'am. You've been accused of one count of theft between $100 and $750, 6 counts of theft, petty theft, these are all retail thefts, of less than $100, and 1 count of scheme to defraud. That scheme to defraud is a felony. Ms. Merchant, I did take a look at the dates of these offenses. So what it appears happened is you got arrested and charged, you entered a plea to probation, and that triggered Walmart to go back and look at further videos from the same payment information. Usually it's the same card, same something. Anyway, when they looked at further previous videos, that led to these charges. So this does not violate your probation because these charges all allegedly occurred before you were even on probation. So I'm going to address your bond or your release status in just a moment. Let me hear from the attorneys and see if they have any additional information they want to make sure I'm aware of. Mr. McDaniel, anything on behalf of Ms. Merchant?
No, just that she's locally, and as far as I know, she's been complying and reporting in at probation. So I don't think she's a flight risk. So we just asked the court to take those things into consideration.
Mr. McDaniel, I'm probably not going to give her a conditional release because of the felony and the number of charges, but she certainly, I'm not going to set her a normal bond. I'm set her something a little lower than that, most likely. What's her position on the cash bond as opposed to a surety bond?
Yeah.
Cash bond, Your Honor.
Mr. Mitchell, objection?
No objection to a cash bond.
Ms. Merchant, I'm going to set your bond at $100 each on the 7 misdemeanors, $250 cash only on all of these. On the felony, that makes your total bond be $9,500. Excuse me, $950. $950 cash is your bond. Your bond has a condition of no contact with the alleged victim, which in this case is Walmart. You probably already have that condition on your probation. You can't go to any Walmart while the case is pending. Ms. Merchant, lastly, we're going to ask the jail to give you a notice for your court date, which should be January 6th.
Yep.
January 6th should be your court date. And they'll give you that notice after first appearance. Do you have any questions, ma'am?
Wait, I'm sorry, do we have any questions?
Yes. Do you have any questions? All right,
No.
ma'am. You'll get his phone in a few minutes to try to post the bond, okay?
Okay, thank you.
Sir, are you here on behalf of Mr. Nix? Anthony Nix is next. We've had friends or family come in the courtroom, Mr. McDaniel, so that's why I'm taking Mr. Nix next. We'll come back to you in just a second, Mr. Tucker. Mr. Nix in the courtroom, I want him to know who's here. What's your relationship to Anthony? Okay, so Mr. Anthony Nix, your father's in the courtroom on your behalf. Mr. Nix, you're here because you've been accused of one count of domestic battery by strangulation. Mr. Nix, there is probable cause for the charge. I do have a few questions relating to bond conditions or whether you're going to get a bond or not, or you're going to get a bond. The question is whether you're going to get a conditional release or not, a bond or release. Mr. Nix, the information I've got is that you're employed at Rex Lumber. Is that accurate?
Yes, sir.
How long have you been there?
I've been there almost a year.
The only prior record I see is an old pretrial intervention. I don't know how old it was. It was several years ago, but it was for allegedly possessing 2 hydrocodone pills. And that case was eventually dismissed. Is that the only history you have? Criminal
Yes, sir.
history, that is?
Yes, sir.
Let me see if
That's
the attorneys have any additional information that I need to be aware of then. Mr. McDaniel, anything on behalf of Mr. Nix?
No, we just asked for conditional release.
Mr. Mitchell?
No, nothing from the state, Your Honor.
Mr. Nix, I don't have a problem with the conditional release, given that additional information. I am concerned about the living situation. Did you and she live together?
Yes, sir, we did. I won't be.
And my question is, do you have somewhere else you can go on a temporary basis other than where she lives?
Yes, sir.
Your dad's saying you've got a place with him if you don't have anywhere else. Is that right?
Yep.
Okay.
Yes, sir.
So,
That's fine.
Given all of that, what I'm going to do is let you pick between a bond and a conditional release. I am going to offer you a conditional release, but everybody that I offer a conditional release to, I give them a bond option. Some people prefer a bond. If you like to post a bond on that charge of domestic battery by strangulation, the bond will be $5,000 cash or surety. But because of your criminal history, I'm going to let you offer you a conditional release. Either way, you'll have a condition of no contact. You'll have the standard conditions of every conditional release plus a condition of no contact. And Mr. Nix, I'll also ask the jail to give you a notice for your court date, which I believe is going to be January 6th at 8:30. So, Mr. Nix, knowing all of that, do you want to accept the conditional release?
Yes, sir.
So let me talk to your father just a second. So, sir, what will happen is they're going to let him get dressed. They'll let him use the phone if he needs to. Then they're going to bring him to the courthouse. The reason for that is so he can meet with Mr. Goodson or Mr. Ham, one of our conditional release officers. That takes 5-10 minutes. And then once he meets with them, he's free to go. Is someone going to be able to pick him up here? So your dad says someone's going to pick you up here. Usually that's 30 to 45 minutes before they'll get him here because get him dressed and processed out and everything. So he'll be downstairs in 30 to 45 minutes, Mr. Nix. Mr. Nix at the jail, do you have any questions?
No, sir.
In the courtroom, any questions? Mr. London Nix? All right, wish you the best, sir. I did say no contact. I believe I said it. I know I did. Okay, so back to Mr. Tucker, the state versus James Tucker. Mr. Tucker, good morning. You're here because I don't need it. You need it. Mr. Tucker, you've been accused of one count of possession of controlled substance without a prescription, one count of possession, drug paraphernalia, and one count of driving with no valid driver's license. There is probable cause for those charges. I did note that the controlled substance is allegedly a single pill or tablet. That's what you're accused of. Your criminal history is very bad. That's probably being gracious. So it's really bad. So I'm going to listen to the attorneys, and I'll be glad to set you a reasonable bond. Mr. McDaniel, anything on behalf of Mr. Tucker?
Your Honor, I mean, I think we just want to ask for a reasonable bond. I think the bigger issue is driving it, just, the no valid license. I know we've dealt with him several times, but.
You my lawyer?
I am, but I'm trying
No,
to.
come on.
I'm trying to.
Come on now.
Mr. Mitchell, anything?
Your Honor, we just request a reasonable bond with conditions of random UAs and
I didn't look at his driving history, but if it's significant, we request no driving.
So, Mr. Tucker, I think what Mr. McDaniel was implying is I'm probably, even if you didn't have the felony, I probably would have set you a bond on the other two. I would have. I wouldn't have given you a conditional release even without the felony. So I think he kind of knows how I do things. It's because of your driving record primarily. I think this says it's at least your third no valid, maybe your fifth. It's one or the other. So I'm going to set you 3 misdemeanor bonds. Now, one of them's not a misdemeanor, but I'm setting you a misdemeanor bond because it was a single appeal. Okay. So your bond is $2,500 on each count. Your total bond, Mr. Tucker, is $7,500 cash or surety. You have the right to post it if you go through a bondsman, and if they charge you 10%, it'd be about $750 to get out of jail. Mr. Tucker, you'll get these phone in a few minutes to try to post the bond. They're also going to give you a notice for your next court date, and that would be January 6th at 8:30. Your bond has conditions of random urinalysis and not to drive without a valid driver's license. If you can get a driver's license, drive all you want. But if you get caught driving without a valid driver's license while you're out on bond, that would revoke your bond. Mr. Tucker, do you have any questions, sir?
No, sir.
Wish you the best, sir. We have Willie Ruth Pittman.
Your Honor, can we do the Pittmans last, maybe go down to Anthony Hearns?
Sure. Anthony Hearns. Mr. Hearns, good morning. Mr. Hearns, you're here because you've been accused of 1 count of possession of methamphetamine, 1 count of possession of drug paraphernalia, and 1 count of resisting an officer without violence. Mr. Hearns, I did read the complaint. There is probable cause for the charges. I also looked at your criminal history, Mr. Hearns. I think you're entitled to a bond. Let me make sure I'm not missing anything that the attorneys want to make sure I'm aware of before I set that bond. Mr. McDaniel, anything on behalf of Mr. Hearns?
No, Your Honor.
Mr. Mitchell.
We just request he be subject to random UAs.
Mr. Hearns, I'm going to set you the normal bonds I would set for these charges, sir. The bond on the methamphetamine is $5,000. The other 2 misdemeanor bonds would be $2,500. Your total bond, Mr. Hearns, is $10,000. Cash or surety. You do have a condition of random urinalysis on the bond. Mr. Hearns, you will get to use the phone in just a few minutes, sir, to try to post a bond. If you post it, you'll be released. If you're not able to post the bond, the public defender's office will be in contact with you at the jail. Mr. Hearns, also, I'm going to ask the jail to give you a notice for the felony arraignment date, which is January 6th at 8:30. Mr. Hearns, it was your father, a Hearns?
Yes, sir.
Which one? Was he one of the Willies?
His mom, no, my father was murdered in Jackson County back in '89 or something like that. But no,
Okay.
Willie Hearns is my brother. Willie
Well, now,
was my brother.
There's more than Willie. There's more than one Willie. There was Willie A, Willie B,
Willie
and Willie
A
C.
and Willie B.
Willie, and
Willie-
I went to
Willie A
school.
and
With,
Willie-
I went to school with. I think Willie B is the one I went to school with at Grand
sir.
Ridge.
Yes,
So,
sir.
Mr. Hearns, you'll get to use the phone in just a few minutes. Any questions, sir?
No, sir.
Wish you the best, Mr. Hearns.
Thank you.
Mr. Gill, I apologize. I should have already tried to take your case. What case are you here on?
I'm not waiting in line. I'm just want to make sure that.
You're the one that Mr. McDaniel needs to take last. Okay. Shamari Garrett, Miss Garrett, good morning, ma'am. You're here because you've been accused of 1 count of petty theft in case 25262 MM. Miss Garrett, ma'am, there is probable cause in that complaint. I'm appointing the public defender's office to represent you, ma'am. I want to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke with Ms. Garrett in 25262 MM. She's going to accept the PTI offer from the state. It'll be 6 months. She'll take a retail theft class. It'll be restitution of $155.39. She'll have no contact with Walmart. Be a $370 fine. And states agreed not to file MRV 24168, 169, 170. And this will resolve this case this morning.
Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor.
Miss Garrett, did you hear that agreement, ma'am?
Yes, sir.
He didn't say that. You sure? The court costs and fines are $370, Mr. McDaniel?
Correct.
Yes. Okay. Miss Garrett, is that the program do you want to enter that PTI program, ma'am? Do you want to do what your attorney put on the record?
Yes, sir.
Miss Garrett, yeah, I explained to everyone that every PTI comes with a conditional release, and here's why that's important. That gives some teeth to the program. If you violate the PTI, and what that means is if you get caught going to Walmart, was this a Walmart case?
Yes.
Yeah. If you get caught going to Walmart, if you get charged with a new crime, if you don't report in like you're supposed to, if you violate in any substantial and material way, you could go to jail with no bond. That's what the conditional release does. You understand all of that?
Yes, sir.
Okay.
No question.
And you still want to participate in the program, right, ma'am?
Yes, sir.
Ms. Garrett, I'm going to show you a case referred to the pretrial intervention program for 6 months, 25-262 MM. The conditions will be asked Mr. McDaniel placed on the record, ma'am. Ms. Garrett, try to get everything done early, because if you get everything done early, you very well may get off the probation, or not the probation, the supervision early. Ms. Garrett, at 3 months, at the halfway point, if you got everything done, there's a good chance the probation office, the PTI office will go ahead and send a letter or an email to Mr. Mitchell asking if he wants to dismiss the case early. And normally the state will do that if everyone's done everything they're supposed to. What's going to happen next is they're going to let you use the phone, ma'am. After you use the phone, they're going to bring you to the courthouse, because that's where the PTI office is at. Once you get instructed by the PTI officer, you'll be free to leave. If you do call friends or family, you need to tell them you can be picked up at the courthouse in 30 to 45 minutes. Any questions?
No, sir.
Have a good day, ma'am.
You too.
We've already seen Nick, we've already seen Mr. Perkins. Is Mr. McCardle? Mr. McCardle, good morning. Mr. McCardle, you're here again. We started to resolve your case yesterday, and we had some questions. Mr. Goodson's back today if needed. So you're here for the charge of violation of county probation in 24-504 CT. I've already appointed Mr. McDaniel's office to represent you. Please listen to Mr. McDaniel.
Your Honor, I spoke with Mr. McCardle in 24-504 CT. He's going to admit that he violated his probation. You understand, he'll serve 30 days in the county jail. He'll have 5 days jail credit. And whatever fines and costs that are associated with the case, he'll either work off here in the jail, or there'll be a civil judgment.
Is $1,179 on his fine balance, Mr. McDaniel.
Thank you, sir.
Thank you both. Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor.
Mr. McCardle, did you hear that agreement?
Yes, sir.
Mr. McCardle, do you have any questions about that agreement?
No, sir.
Mr. McCardle, is that the admission you would like to enter, sir?
Yes, sir.
Mr. McCardle, I'm going to accept your admission that you violated the terms and conditions of your supervision. In case number 24-504 CT, I'm going to revoke that supervision. I'm going to sentence you as agreed to 30 days in the Jackson County Jail, 5 days credit. Remaining court costs and fines are still owed of $1,179. Mr. McCardle, there's no probation involved in this sentence. You finished those 25 days you have left. It may be less than that under Florida game time law. Hopefully it will be. At most, it's 25 days. But the jail can explain to you the game time laws in Florida. Mr. McCardle, there's no probation involved in this sentence. You finish this jail sentence, this case is over. Any questions, sir?
Judge, would you consider letting him turn himself in Monday morning here at the jail and finish up that jail sentence?
So I could eat one family?
No.
I mean, I
No,
turned myself in
the reason is that I already agreed to change the sentence from 60 to 30, so you could be out for
Okay.
Christmas. So
Yes, sir.
you're going to be out for Christmas, but not Thanksgiving. Now, if you want to go back to 60 days, I'd probably let you out for Thanksgiving if you told me Thanksgiving was more important.
No, sir.
All
I
right.
appreciate you.
Wish you the best, sir. Then we have, which Pittman do you want to take first? Miss Willie Ruth or
Willie
Mr.
Pittman, I
Randall?
guess Willie Pittman's not in here. Did you get my text message? She's
I
just too
did,
sick
and so this is state of Florida
They're trying
versus
to
Willie
force
Ruth Pittman. This is state of Florida versus Willie Ruth Pittman. She's charged with battery on law enforcement officer. There is a complaint. There is probable cause. And Miss Pittman's unable to attend first appearance this morning, and is due to medical or mental health reasons, Mr. McDaniel.
Yeah, they're trying to force her to eat, I think, and she's having some, just medical issues, and she's not eating, and, they're trying to get her to eat, I think, right now. I think they're just about there being as nice as they can to her, but medical issues and mental health issues.
Mr. Gill, anything from the state?
Judge, we'll defer to the court. We have no objections to proceeding in absentia on a bond analysis. If that's what the court wants to do.
Mr. McDaniel, law enforcement contacted me before making the arrest about whether a warrant, probable cause, and PC questions. Basically, I think they did everything they could within their power to try to find an alternative to this, including attempting to contact state agencies and looking for family members to take Ms. Pittman. And the other defendant, Mr. Pittman, recently checked her out of a facility that it took months and months to get her in. So there was no one to care for her. So I think this was kind of a option of last resort. They couldn't leave her alone. So there's certainly probable cause for a crime. I'm gonna set her a bond today, a $500 cash bond. But I'm glad to see her at any point to review that if and when she's able to come to first appearance, Mr. McDaniel. But for today's purposes, she's gonna have a bond of $500 cash, and we'll see where it goes from there. It took months in circuit court to get her in the program last time, I believe. Yeah.
All that work is probably undone.
Yeah, they wouldn't accept her back. So that takes care of her first appearance. That brings us to Mr. Randall Pittman. So Mr. Randall Pittman, come on up, please. Mr. Randall Pittman, good morning. Mr. Pittman, you've been accused of one count of, the first appearance sheet says intent or threat to do violence. I'm assuming it's an assault allegation. Once I read the complaint, that's the assault statute they're using. So you've been accused of one count of misdemeanor assault. And I've been advised through a text this morning, a text to Mr. Mitchell and myself from Mr. McDaniel, that you do not want an attorney appointed to represent you for first appearance purposes. Is that correct?
That's correct, Your Honor.
Okay. So I don't know if I've ever had that at first appearance. Do I have to go through the same analysis for first appearance purposes as I would for representation?
Judge, I don't think I've ever seen that either.
But I think it is each stage of the proceeding that you have to inform him of his pro se rights.
Okay. So you have the right to an attorney. That's the best thing to do, especially if you don't have any legal background or legal training. But if you want to represent yourself, you're going to have to let me talk. That's one thing attorneys do, is they let the judge talk, and then you'll get a chance. We take turns. That's kind of how it goes. So I've got to ask you some questions to see if, about your educational background and your desire to represent yourself. And I've got to stress to you the importance of why that may be a bad idea. So tell me about your educational background, Mr. Pittman.
I went to Cottondale High School.
Okay. Any college?
Initially, and then I got transferred over to Gracefield High School.
Any college?
I have a bachelor's degree. My brother and I received scholarships at Marshall University, football scholarships.
Okay.
I played
Mr.
football.
Pittman, what is your bachelor's degree in some kind of legal studies or something totally different?
My degree is in business administration.
Okay. Mr. Pittman, did you have any postgraduate work? Did you work towards a master's or anything?
Well, I've been working undercover for the state of California for about 20 years as an attorney general.
Mr. Pittman, as an attorney general?
And that's a sad point for Jackson County because they didn't know that. But I had to reveal that now because I'm in court.
Mr. Pittman, have you ever been to law school?
I've been going up and up. I'm sorry.
Have you ever been to law school?
I'm sorry.
I need you to listen to my questions, Mr. Pittman. I'm asking you specific questions for a specific reason. Have you ever been to law school?
No, I've never been to law school.
Okay. So here's what you got to understand. Mr. McDaniel has been to law school, an accredited law school. He's graduated from that law school. And then after that, he took and passed the Florida bar. And after that, he's been practicing law, Mr. McDaniel, in excess of 20 years. Is that right?
Correct.
So here's the thing. This is what I heard a judge explain it to me one time, and explain it to a defendant, and I was in the courtroom. You're about to enter a process, and the way the judge described it, you're about to have surgery. And what you're saying is that even though there's a surgeon here next to me who's willing to do the surgery, and that's his job, I don't want to do that. I want to go ahead and do surgery on myself. That's essentially the analogy that I'm using for you representing yourself. In other words, it's a bad idea. Knowing that, you still want to waive your right to an attorney and represent yourself for first appearance purposes.
Your Honor, I promise you, I'm the best attorney in the nation. I promise you that. So
do
I'm
you want
willing
to represent yourself for first appearance purposes?
Yes, I do. Yes, I do.
All right. So do you want to be heard on the issue of probable cause?
Yes, I do.
Go ahead, please.
First of all, Your Honor, this was really a bad decision by the sheriff's department. Enfield, he's the one who he tells these guys to do this every time to me and my mom. He's already told me, I don't care where you take your mom, but you need to get her out of Jackson County. So that's why all this stuff keeps happening. It's called Enfield. And honestly, Judge Garcia, she's a good and fair judge, but she is being controlled by Enfield. That's why all this stuff is going on.
Your Honor, we're gonna.
All right, so Mr. Pittman, that's nothing to do with probable cause. That's just you rambling. So I'm not gonna listen to any more of that. Mr. Pittman, before you elected not to use him, Mr. McDaniel sent a text this morning to Mr. Mitchell and myself questioning whether there was probable cause in your case. And his question was that it appears to be a conditional threat, and conditional threats typically cannot qualify as assault because the assault statute says the threat must be imminent. That's the key word in this particular analysis. Mr. Mitchell, any position on, or Mr. Gill, either one of you, on whether or not this meets the basis for probable cause for assault?
Judge, it does appear to be a conditional type of analysis. We would ask for 24 hours to amend. There could be facts that were not put in the probable cause affidavit to establish a charge for assault.
Okay, thank you, Mr. Gill. So the complaint says that you allegedly went to where those two people were at, and that may be considered an overt act, which may have a basis or a part of the analysis to determine whether or not there's assault or another crime. So what I'm going to do is I'm going to determine there's no probable cause for assault. But based upon your criminal history, as well as the recent mental health history that the record reflects,
I have no criminal history,
in the other
Your Honor.
case,
I have zero criminal history. I have zero criminal history.
You do have criminal history. You've been arrested within the last few months for a case involving your mother, correct?
They were all dropped. All those charges have been dropped.
Okay.
Did you not hear?
Fair enough. Fair enough. They were dismissed. You were arrested, but not dismissed. They're still part of your history. They're just not convictions. I'm going to hold you for 24 hours. I'm going to see you tomorrow morning. If they haven't amended the complaint to include probable cause, then I have to release you. That's the law. It's very clear. If they have amended the complaint, then what's going to happen is I will see if the amended complaint includes probable cause for a crime. If it does, I'll set you an appropriate bond or consider other release options. So I will see you in the morning.
You're not going to give me bond today?
You're not getting a bond today because there's no probable cause for a crime. Now, if you want to waive the argument of no probable cause, since you're representing yourself, and agree that there's probable cause or stipulate that you're not contesting that, then I can set you a bond today. Otherwise, I can't set you a bond.
Yes, I'll do that. I need a bond today.
So you want to stipulate only for first appearance purposes that there's. Okay, you want to stipulate for first appearance purposes. Well, your mom's going to be in jail, and you're going to have to contact with your mom. I'm fixing to do a no contact order once I find probable cause based upon the history.
You got to be kidding me.
Absolutely going to do no contact. That is absolutely going to happen. You're going to have no contact with your mother because I think you're a danger to her. So my question for you is, do you want to waive any objection to probable cause so that I can set you a bond, or you want me to see you tomorrow and see if they can establish probable cause?
Yes, I want the bond.
Okay. Mr. Gill, you'd like to be heard on the bond.
Judge, we'd just be asking for a reasonable bond, and we would be asking for no contact with Willie Ruth Pittman.
Your bond's $5,000 cash or surety with a condition of no contact with your mother. To me, that is an absolute necessity to ensure her well-being. You have the right to use the phone to post the bond, sir. If you post the bond, you'll be released. Any questions, Mr. Pittman? Court date. January 5th court date. If you give him that notice, please, that would be at 9 a.m. You'll get his phone in just a few minutes, sir, okay? Have a good day.
Sir.
Mr. McNally, anything else from the public defender's office?
Nothing else, Your Honor. We appreciate it.
Mr. Gill, Mr. Mitchell? All right, ladies and gentlemen, it's 8:54. We're through with first appearance.
Well, that was a very interesting set of contestants there with Judge Mercer, and nice to see the quote-unquote best attorney in the nation participating there at the end. That was really nice. Today is very content-rich. I hope you're all enjoying yourselves. I know I am. It's been interesting today. Let's see if we can keep it interesting. Let's go to Judge McNally.
Your name? Eric. So we need Emily. So we set we set a sentence date after you pled guilty to failure to submit to testing. You were going to go to your doctor. Did you go there?
I did. It was yesterday.
Did he give you a report?
He gave me just basically like a note. I tried to read.
Do you have it with you?
I sent it to Emily this morning. It was just like I saw you yesterday note, though it wasn't much. So I did reach out. They don't know if there's like 9 to get you a report. She's on there. And then they gave me a prescription for something that she said was fine.
So is he saying that you've got shy bladder syndrome?
That and for it.
All right, let me get her in here. And we'll see what the letter says.
It was basically, I saw you yesterday. That was just gonna show you much.
Well, that isn't enough.
I know it's not, that's why I said I reached back out already.
I need shy bladder syndrome diagnosis.
You did say it a few times, it's just not a no.
It just says, I saw you yesterday.
Pretty much. I saw you meet this person on the 24th.
Let me see what we can do here, okay? Just give me 1 second. See. If you need those or not. Unless I keep a couple up here, I could. Okay. Okay. Yeah. All right, so first of all, let me tell you something. You have a right to a lawyer. I'll be happy to provide you with one at public expense if you would like one. Would you like a lawyer to represent you?
Yes.
Pardon? Okay, so let me see what she has to say. Do you have anything to say?
No. They have to, it go in.
All right. Why don't you have a seat? Just have a seat until she gets back. Okay? Thanks. You can sit right there at the table if you'd like. See. All right. Do we have this other gentleman's case here, John, or not?
He has a case with the state prosecutor field.
All right, recalling Eric Stefan Kish, 25F244490. Mr. Sino, your name?
Emily Tessino.
Sir, your name?
Eric.
All right, you still wish to waive your right to a lawyer? And you don't have anything to say? He says he had a letter from his doctor just saying he was there. That wasn't the point.
That's what I said. I was, the guy responded and said he didn't give you any other information. He said that he gave him a prescription and I looked it up and it, or he's giving you a prescription. Yeah, so I looked it up and what it says the prescription does relate to the testing issue.
Does?
Yes,
It's gonna help him urinate.
yes.
Well, then let's set this for sentencing again. I'm sorry. If you want to go back and get the diagnosis of shy bladder syndrome, I'll require DNA. Is that where you're testing primarily?
Yeah. And all his testing has been fine since. He went the 3rd, the 8th, 12th, the 16th, the 18th, and the 23rd.
You've been testing all those times?
I tested every time. I only missed the one due to this. I go back a lot of the times, like I'll go in the morning and usually go and pop back up later, but.
Look, let's just do this.
Sunday it took 3 attempts, I was there.
So all those tests have been negative.
it's on the Silver Lake as well.
Good enough. I'm gonna assess costs of $50. You pay that now, I'll keep you on probation. Just make sure you're going, okay? If not, I'm gonna need a diagnosis of shy bladder syndrome, then I'll have them do a pat-down search. Okay. We didn't advise them to do a pat-down. I remember doing that on,
We talked about seeing if it helped, but we didn't.
Okay.
So I'm hoping that the medication helps and.
good enough. Good enough.
Okay.
Thank you. Good luck. Thanks a lot. Have a nice Thanksgiving.
clevelandclinic.org, shy bladder syndrome, also known as paresis. Shy bladder syndrome is a social anxiety disorder making it difficult or impossible to urinate in public restrooms or by people nearby. People with shy bladder avoid using toilets that aren't in their homes. Untreated, this condition can lead to urinary problems and difficulty with work and relationships. Therapy can help. The Cleveland Clinic, ladies and gentlemen.
They changed it from a requirement to a strong recommendation, which I don't
Hang on.
know. But it should have, unless I gave you the wrong floor, which,
It was dated today.
okay. Yeah, I may have signed the wrong form. I double check it, Judge. Make sure I did print and sign.
I mean, let me take a look. Give me 1 sec.
Okay.
Mr. Muhammad, how are you this morning? Good, thanks. Wait. I want you to come here, please. Ma'am, your name?
My name is Lexi Dan Yarner.
Whoever has that phone.
You have to take that out of here, please, sir. If the defendant, Mr. Muhammad, your name?
Good morning, Your Honor. Muhammad, happy people.
If the defendant fails out of the sobriety or specialty court due to poor performance, commits another crime while on probation recommendation, or the judge finds sufficient cause to terminate probation, then the balance of the year or 1 year must be served in jail, no work release or waiver.
Your Honor, I may have printed and signed the wrong form. Can I double check that?
Yeah,
I don't want to get Mr. Muhammad in trouble.
Well, nobody's getting anybody in trouble. I just still don't feel comfortable that that's the best we can do. So we'll have to go to the exam. The exam's today, right?
So Judge, that was amended to a strong recommendation, and that portion is not part of the sentence agreement. I'm assuming that form is the old copy.
No, it is it does say strong recommendation on the top. So I think the idea is, Your Honor.
Guys, I don't mean to be rude. How can I read this different than I'm reading? I can't.
Judge, it's not a sentence.
Listen. You said, under strong recommendation?
Yes. It's.
Hang on.
So if I could, Your Honor, I think the idea, okay, sorry.
You know what the idea is? I am not going to ever put myself in a position where somebody says the judge sanctioned this plea agreement and then didn't follow through. I want you to hear me clearly. Nobody's ever going to be able to say that I took a plea. There was an agreement in place. Now, it might say strong recommendation on the left, but any judge reading this, quite honestly, including this one, if the defendant, it's a strong recommendation. I'll give you that in bolds. If the defendant fails out of the sobriety or specialty court due to poor performance, commits another crime while on probation, parents, recommendation, and parents, or the judge finds sufficient cause to terminate probation and the balance of the year or 1 year must be served in jail, no work release or waiver. Now, what does that mean? I know what it means. I don't feel comfortable doing this, guys. If you wanna redo this language and just say, then the prosecutor's office, if the defendant fails out of the sobriety or specialty court due to poor performance, commits another crime while on probation, or the judge finds sufficient cause to terminate probation, the Wayne County Prosecutor's Office stipulates Wayne County Prosecutor's Office recommends that the balance of the year or 1 year should be served in jail. However, the Wayne County Prosecutor's Office leaves this to the court's discretion. I mean, I'm not going to go through with this, guys. I told you, I mean, I'm going to give you the example again. Somebody is 95% compliant and they screw up at the end. They have an addiction. They've done a good job, but they lost it again at the end. I've seen it. It happens. I'm not going to have somebody tell me you have to give them a year in jail. I still go back to what I said. And look, it's okay that we disagree. Maybe you guys need to go to the Wayne County Circuit Court, sobriety court, probation. I have no problem with that. You can waive the exam. I happen to think ours is as good as any around, but I'm a little biased. So if that sounds arrogant, forgive me. But I will do this under these circumstances with this language in it, unless it's clear and unambiguous that this is in the court's discretion. And to the extent somebody can't say that, I understand. It's okay. We'll just agree to disagree. But I can't have somebody tell me this says that it's a recommendation. I realize it's a strong recommendation. And then, by the way, you got on the back here, courtroom APA must be notified if any of the 1 year jail sentence triggers are committed. Now, maybe there's judges that'll read it more liberally. God bless them. It's okay. Everybody doesn't have to agree with me. Everybody, every day, people don't agree with that. It's okay. I get it. They don't have to. Ms. Don, I am so sorry. I don't know what to tell you. You guys can work on this if you want. You can pen it in. You can redo it. You can do what you want. If the office is going to say, Judge, that's the best we can do, then I'm going to say to you, I'm sorry, I'm not doing it. We're going to the exam at 11 a.m. today.
Judge, I may, just in regards to that portion, we are leaving that to the discretion of the court.
You got to write it in here. I'm not going to have I'm not going to go searching for transcripts. This does not look like.
But that's why it was written as a recommendation, not.
You wrote it as a strong recommendation. You put it in the caption, but then it reads like the judge has to do this. I mean, if you can't, listen, I'm not trying to pressure anybody or make anybody feel bad or anything else. This seems like a nice lady here. I'd love to have her in our sobriety court. I think she would be a great candidate. But I feel so strongly about this, and it's not some kind of just an argument. I don't need to argue with anybody at my age, but I just can't do it. So you guys are either going to have to fix it or we're going to exam at 11. Sorry.
No problem. If we have it back, and hopefully we can fix it.
Okay. Hagen Lee, John, can you handle that, please? Hagen Lee Trackwell at 24B 714693. Again, Mr. Muhammad, I want to be clear. If you guys just don't want to do it, it's okay. You're not hurting my feelings. You're not.
I understand.
It
goes through my supervisor.
I know, I get it. I get it. Come on up to the podium if you would, Mr. Trackwell. Mr. Trackwell.
Yes, sir.
Where were you?
I was just calling to some friends.
All right, okay, let me talk to your lawyer. Counsel, your appearance.
Good morning, Your Honor. Attorney Corey Westmoreland, great, no, get out of the well.
Okay, so you didn't show up here for your date on October the 23. So why didn't he show up for his November 23 date, counsel? Can you tell me?
Your Honor, I just had my car repo. I had no way.
Where do you live? You live in Brownstown.
Yeah,
How far do you live from here?
like 15.
All right, well, how'd you get here today?
I got a ride from my mother.
Why didn't you get a ride from your mother on October the 23rd, or take an Uber, or take a cab, or take a Lyft?
Right before my car got repo.
Calling
I was in the midst
Jessica.
of Trying to make sure my girlfriend gets to her OB.
All right, I'm gonna let it go. You can't do this, son.
Yes, Your Honor.
You can't do this. You walk in here 5 weeks later. What if I wasn't here?
Yes, Your Honor.
That'd be rude if I wasn't here since October 23rd and then decided to come in Monday and told you to come in. Counsel, there was no, disposition on this. The charge is failure to refrain from consuming alcohol or drugs, testing positive for cocaine on a chemical test. That's count 1. It's actually an amended show cause dated October the 16th. And then count 2 is failure to refrain from consuming alcohol or drugs, testing positive for alcohol and marijuana on a test of October 16th. So those are the 2 counts. Ms. O'Donnell, your name. Good morning to you. How is he going to proceed?
Yes, Your Honor, after speaking with Mr. Trackwell this morning, we are prepared to waive any sort of contested hearing on your guilt.
Is that what you want to do, sir?
Yes, sir.
You have 1 prior technical violation. This would make 3. I just want you to understand, you could get 15 days if you plead guilty to both of these. That would be 3 technical violations. Do you understand that?
Yes, sir.
Did you sign an advice? Did he sign an advice of rights form today? You are presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses. You have the right to bring in your own witnesses. You have the right to use the subpoena power of the court to bring in those witnesses. If you plead guilty, now wait before we go any further. I'm just going to orally advise you, then you can sign the form, okay? If you plead guilty, you're giving up all of those rights, including your right to a contested hearing. You have the right to remain silent at that hearing, and if you do, that silence would not be held against you. Do you understand?
Yes, sir.
If you plead guilty, we're going to have a disposition hearing, but we're not going to have a hearing as to these 2 counts if you plead guilty. Do you understand that?
Yes, sir.
Any questions before we go on? You understand everything?
Yes, sir.
There's the count 1 that you fail to refrain from consuming alcohol or drugs, testing positive for cocaine on October 6th of 25. How do you plead?
Guilty, Your Honor.
Did you test positive on a chemical test on October 6th of 25 for cocaine?
Yes, sir.
Did you consume cocaine within the, say, preceding 72 hours?
Yes, sir.
As the count 2. Did you fail to refrain from consuming alcohol or drugs, testing positive for alcohol and marijuana on a chemical test of October 16? How do you plead?
Guilty.
Did you test positive for alcohol and marijuana on that date? Hang on 1 second, just listen to my question. And did you consume alcohol and marijuana, say, within the 3 days preceding that, at least the alcohol?
Yeah.
Did you consume marijuana, say, within a week of that date?
No.
When did you consume marijuana?
It was probably a week prior from me seeing my probation officer, so.
Wait a minute. Let's talk about the test date of October 16th.
Yeah, marijuana was still in my system
Slow down.
from being.
Slow down. When did you last use marijuana? I sentenced you in this case on October 15th. I see. But I told you not, Judge Hessen told you not to consume alcohol or marijuana on July 17th to 24, and you absconded, right? Right?
Oh,
On the bond.
yes.
You were told not to drink alcohol or consume marijuana, correct?
Yes.
And then you absconded for the longest time, right?
Yes.
And you realize those bond conditions were still in effect, right? She never lifted those, did she? She never told you
no.
you could use marijuana and drink, did she?
No.
Are you on probation or parole for anything else?
No.
anybody force you to plead guilty?
No.
I'm gonna find you guilty if I find the plea has been made voluntarily and understandingly. Please accept it to being positive for cocaine and positive for alcohol. Cocaine being on October 6th test. Count 2 for alcohol, October 16th. There's still enough there to show that you at least violated a bond, but at least you're guilty of consuming alcohol. Now, look, this case was disposed of, or at least by plea, on October 1 of 24 after, I'm sorry, as a bench trial. And we are still wait a minute. I sent you October 15 of 24.
Yes. I only went for one director or something. Sure, yeah.
He was sentenced to probation October 15th of 2024. He was on probation.
Right, and these tests happened on October 6th of 25.
A violation was issued back in September. He went into warrant status, turned himself in. He extended his probation 3 months. And then I issued this other violation October 23rd of 2025. He didn't appear. There was issued a warrant and he turned himself in today on that. And Judge, if I could, regarding the test on October 16th, he did go back after the fact, after I issued it, and did pay for the lab. He didn't pay for the lab confirmation on the marijuana, but he did pay for it on the alcohol. The alcohol confirmation did come back positive. ETG was greater than 10,000 and ETS was also greater than 10,000, Your Honor.
This is becoming complex, Mr. Trackwell. What do you have to say? Anything?
Your Honor, I would like to know that Mr. Trackwell did check himself into Corwell Lane Mental Hospital. He was there for approximately 4 days.
When was that?
I believe the 25th
Of what?
or the 22nd of this month.
Were you back in September at a mental health facility? Listen to my question. On September 2nd, were you in a mental health facility on or about that date? September 2nd?
I don't recall. I don't recall, Your Honor. I was just, they took me to court, well, I was there for like 4 or 5 days.
And you're saying, but there's a note in here that you went to a mental health facility in September.
I probably did, but I just was there recently.
I understand. What else would you
Your
like?
Honor, he currently is looking for gainful employment. He's having a tough time doing so, being that he doesn't have a car. But he's looking to get his life back on track. He walked himself in here today, proceeding most of this was pending. He wants to clear this up. He does have a strong family support. His mother and his girlfriend are currently in the courtroom.
Where? You're his mother? Come on up here. I don't usually do this, certainly not with somebody who's in their early 20s, but I want to talk to you. Can you? How are you?
Hey, how are you?
Good. Your name?
Janet Trackwell?
You got to get your son on track, so to speak. Okay? He's not doing it. I believe you. I don't know the extent of his issue, but he's ignored us. And he's not doing what he's supposed to do. Did you graduate high school? Do you have a GED?
No. I took the test.
That's great. He went up to. He's had some history between myself and his father. His father does have addiction and mental health issues out of state, and he's not been consistent within his life. So
What do you think?
I'm very concerned. We go back and forth. Kagan will do okay for a little while. He'll then violate probation. I'll issue a violation. He doesn't show up for the hearing. He'll then go on warrant status for a couple months and then he comes back around again. I am very concerned. And again, the last report I have from his mental health treatment's back in August. So I don't know if he's been.
Has he been going?
no, he's been avoiding everything. I sent a message just to last week or.
He's been what?
I just sent a message to Jessica a couple weeks ago through email because I have the concern that he continues to blow everybody off up under any kind of authority who's trying to put him on the right track.
Hagan, have you ever been to jail?
Yes, sir.
Where?
Murray County, Tennessee.
How long?
I just went to prison.
Pardon?
Before my dad went to prison.
Yeah, but how, I'm worried about you right now.
Yeah, it's locked up in Murray County, Tennessee
How long?
for like a week.
Was that a county jail?
Yeah, it was,
What was it for?
for, that of, Plan B from the Kroger.
Why aren't you going to mental health treatment?
Just got my services set back up. I have my case
When did you
manager,
last go to mental health treatment?
I think last month. Was it last month? It's about a couple months.
What are you fooling around with cocaine for, son? You can't do this.
It's got-
Well, you can be the leader.
Yes, sir.
I mean, I don't want to make you feel bad, but they're only giving you one of these things called life. And you're not working, you only have a 10th grade education. You're violating left and right. You're not doing what we told you. I mean, I'm surprised. Can I tell you something? The more I look at this file, the only reason I think I gave you another chance, because you've blown us off for so long, is because I wanted you to do some mental health treatment. I thought that would help. No. Let me see. No, get the other one that I got like this. Okay. Well, let me see. That might be it.
That's a whole, that's it.
Thank you. I don't think I can do anything here other than send you to jail, and I don't want to send you to jail. What do you think?
I don't know what else we can do for him at this point. I am happy that he's back with his mom. I think that is a good support system, but he'll stay with her for a little bit and then he leaves and she doesn't know where he is for a couple months, couple weeks. So the back and forth, if he stays with her, I think things are a little bit better. She at least tries to hold him a little more accountable, but I don't know if he'll ever stick with that though. He hasn't shown in the past that he has.
Who says he paid all his fines?
I believe it's $145 still.
We pay that.
Not today, but I've been paying everything.
Judge too, I do want to note, this case is taken under the domestic violence status as well, the special status.
Well, I don't have any choice but to revoke that. 769.4A status revoked. I know I hadn't done that. Conviction entered. I'm gonna sentence him anew. I'm gonna need a first page of a misdemeanor register. I'll be right with you, Ms. Tucker. My apologies.
Thank you, Your Honor.
So I'm gonna sentence him anew, I guess, and you know, I don't know what else to do with it.
Yeah. You give me one more chance.
I think you told me that, but.
Clean up, do better. I think the steps I need to do from the. I love it.
I could sit here and never send anybody to jail. It would make my year. But I can't let this go on. I cannot let this go on. All right, so I'm going to sentence him anew. Is there anything else anybody wants to say? So I'm revoking his status, entering the conviction. I'll sentence him now. Does he have any credit for time served coming for court work or community service? Let me see.
24 hours of community service, Your Honor.
Anything else, counsel?
Your Honor, it sounds like he's back home where he does have some direction and some oversight from his mother. I would just ask that be taken into consideration to potentially give him one last opportunity on probation.
There's no way you can pay the $145 today, or $200 is what I'm gonna check. We're not open Thursday or Friday. Here's what I'm doing. Did I let you finish anything else?
So.
Lisa, please listen carefully. You do such a good job on these, but I want to make sure that this just says, I'll tell you in a second. 100 fines, 100 costs, $200 in 93 days, credit 4. So you're going to serve 89. I will suspend 75 days if the fines and costs are paid. The $200 is paid by Monday. So you're going to only have to serve 14 then. So if the defendant pays fines and costs, we'll suspend 75. And that's a gift. And I'm going to tell you why I'm doing this, and one reason only. Because I'm still hopeful that you're going to get yourself with your mental health issues soon. You cannot do this. You're ruining your life, and you can do it, but you need to get some help. There's nothing wrong with acknowledging we have a problem and moving forward and trying to correct it, or at least get it under control. But you're not treating, you're doing cocaine. That's what I'm going to do. That's a gift, son. You're in custody. "21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal." Ma'am, I'm sorry. I really am. Have a good day. Good luck.
Interesting day in Judge McNally's court as well. Been an interesting day all around. Much more interesting than I thought it would be. But that's good. We like to have fun here at TCF. Let's go back to Lake County. Judge Collada has a new contestant. Let's see what's going on there.
State of Ohio versus Aaron Seymour, case number 25 CR 134. Defendant is present in the courtroom and represented by defense counsel. We're here today for a pretrial. Your Honor, I sent discovery yesterday, and this morning I handed Mr. Patika the offer in this case.
Hang on one second. All right, what's the offer?
The offer is a plea to count 1. No recommendation as to sentencing at this time. State would ask for a pre-sentence report, drug and alcohol evaluation. I have a copy of the offer for the court.
You can get a stamp.
I have nothing further.
Can you give me a brief summary as to what the facts are here?
This was a traffic stop conducted by the Courtroom Police Department, and upon a search of the vehicle, the narcotics were found in 2 different places in the vehicle.
Does the defendant have any history?
The defendant has a
some in Geauga County, wasn't there one?
He has a pending case in Geauga County. Don't have the details of his history now before me.
I'm sorry?
I don't have the details. It's a very minimal record. Okay. At the time that he was pulled over, he had a firearm. He was allowed to have it. It's kind of what started more of the conversation with police officers that ultimately led to a search of the vehicle because he did not have a valid driver's license.
All right, thank you. Mr. Patika, you received discovery?
Good morning. Yes, we received discovery earlier this morning. I shared a copy of the offer with Mr. Seymour, and we understand that we have a trial date on January 20th.
Okay. Is there, if you just got discovery, maybe you could look at it. Are you aware whether there's any suppression issues here? And if not, that's fine.
Mr. Grecky provided me with the police report yesterday. The initial stop was for a loud muffler. I'd like to take a look and see if they have any dash cam concerning that.
Okay.
But other than that, it was a consent search once the car was stopped.
Okay. When is our trial date?
January 20th.
See that on here. All right, Mr. Seymour, as I explained when you were here last time with this OR bond, that means you, nothing's changing there. You're being released on the OR bond still. But you need to appear at all future court dates. Your failure to appear is a separate felony that, again, is more serious than what you're charged with here. So it's obviously important to show up at all your future court dates. Your next court date at this point is January 20th. That would be the trial. If this case is going to resolve in any type of plea, that's not going to happen on the 20th. It'll be before that. Your lawyer will be required to let the court know no later than 2 weeks before the trial date as to whether this is going to be a plea or not. So he will have to let us know by January 6th whether you're going to accept an offer from the state and enter a plea. So you're going to need to obviously meet with him and let him know that before that date. If it's going to be a plea, then he'll let us know, and we will schedule a date for you to come in here for a plea hearing, which again will be before the 20th. So we obviously don't know that now because we don't even know if it's going to be a plea, so I can't tell you when that will be. But if you agree with your lawyer to enter a plea, I just need you to know it will be before the 20th. It's going to be your responsibility to make sure you find out when that is. Your lawyer will tell you, but if for whatever reason you don't get that information, you need to reach out to him. You can reach out to the court. You can go online and look. There's plenty of ways to find that out. But you'll need to be here on that day, whenever that is then. It'll be before the 20th. You understand that?
Yes.
All right. All right, I think that covers everything. Anything else for the record?
No, thank you, Your Honor.
No, Your Honor.
All right, I'm going to sit up here for a moment so you guys can take off. Thank you.
Thank you.
Much shorter and sweeter than the last time we went to this court this morning. Let's go back to Judge Simpson.
The city of Chelsea, Washington County, state of Michigan. What do you do that makes you think that you're guilty?
Use counterfeit money to purchase stuff at stores.
All right. So you had money that you knew was counterfeit?
Yes, sir.
And you used that money to purchase items at various places?
Yes, sir.
All right. The amount of these purchases or the amount of counterfeit bills that you intended on passing or bought those items with, was it more than $200?
Yes, sir.
What's the amount of money that you got back?
Probably like 50.
Pardon?
Probably like 50.
So you only used $50 of counterfeit bills?
So I used probably like around 300.
Which is a bigger number than 2, right?
Yes, sir.
Yeah, okay. All right. Maybe not in counterfeit, I don't know. All right. And so, and your intent was to mislead these various places and or businesses that the monies that you were giving them was real. Is that correct?
Sure.
Sir, I do have to advise you that if between the time of my taking your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any recommendation or sentence evaluation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
People are satisfied, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be January 5th, 2026, 9 a.m. That's before Judge Freshour. Bond will continue.
And Your Honor, if I may just address bond briefly. Mr. Williams is on a GPS tether. I don't believe that there have been any violations of that tether that I've been made aware of, and he has appeared for all of his court dates. He asked that the court considers removing the GPS tether.
Any response from people? Not that I need one. I don't need a response. Motion is denied. I'm going to continue to tether on.
Thank you, Your Honor.
I think she's. Court does call the case. People versus Alan Rogers.
Sandra White on behalf of Alan Rogers.
Your name, sir?
Alan Rogers.
Thank you.
Your Honor, I'm asking for an adjournment for further negotiations with the prosecutor.
Probable cause conference will be adjourned December 4th, 2025. And bond in this matter will continue. Thank you. Court calls case People versus Joel Serbinoff.
Courtroom on behalf of Mr. Serbinoff, who's appearing by Zoom. Serbinoff, please unmute yourself, turn on your camera, state your name for the court.
Joel Serbinoff.
Judge, today is the date and time set for probable cause conference. We are working on an offer trying to get Mr. Serbinoff into treatment court, so we are asking for an adjournment at this time.
Probable cause conference will be adjourned December 11th, 2025, 9 a.m. Bond will continue.
Thank you, Judge. You're free to.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Kevin Smith.
For the people.
Good morning, Your Honor. Assistant Public Defender Davi Leba for Mr. Smith, who stands to my right. Mr. Smith, could you please tell the court your name, sir?
Kevin LeBron Smith.
What are we doing?
Your Honor, I'd like to request an adjournment, and I'd also like to address bond, please.
December 4th, 2025, 9 a.m. as to bond.
Thank you, Your Honor. So I just talked to Mr. Smith yesterday. He tells me that he's suffering from bipolar schizophrenia and does need medication for that. He could stay with his mother if released. We would have no objection to a home confinement tether to ensure his appearance at court, which I believe was the reason for his remand. I would note this is a non-violent case where the allegations are simply theft of books from a library, and I do believe that a tether would ameliorate any concerns regarding the previous failure to appear.
Response.
As defense counsel stated, previous failure to appear. I believe we were looking at mental health treatment court for this person. That was the goal of the people, was to get him into that specialty court so we could have support necessary. Concern anything at this time before he's trained in the treatment court would not set him up for success. I would ask that the court continue the bond, train the next 10 days, and we'll be able to.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Antoine Thomas. Sir, you got to keep moving.
For the people.
Carbadell on behalf of Mr. Thomas, who's approaching the podium, will be standing to my right. Mr. Thomas, when you go up here, please state your name for the record.
Antoine D'Angelo Thomas. Thank you. Take your hands out of your pockets, please.
Your Honor, today is the date and time set for probable cause conference. Again, similar to my last case, we are working on getting Mr. Thomas involved in treatment court. So we are asking that for a brief adjournment at this time. It is out county, so a bit of an extended.
December 11th, 2025, 9 a.m. Bond continue. Court calls case of the People versus Bonnie St. John.
For the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. St. John. Ms. St. John, state your name for the record.
St. John.
Thank you.
Your Honor, we are asking for an adjournment of the PCC for negotiations, and I would like to address bond.
Probable cause conference will be adjourned to December 4th, 2025, 9 a.m. as to bond.
Your Honor, Miss St. John is requesting a personal bond. She has a number of reasons why she would like to go home. The most important is her medical conditions. She has Parkinson's that is worsening daily. She is on a number of medications for that. She also has diabetes, significant pain that she deals with, and she's also undergoing testing for potential cancer. Those things are obviously hard to do in the jail. And so Ms. St. John would like you to take that into consideration. This case is a drug case. She has set up treatment at Gretchen's place in Belleville. She was about to go there when she was picked up on this warrant. So if
that before or after her use of cocaine?
I believe that was after.
Oh,
She organized that treatment. So if she were to be released, she would be attending classes there. She's also engaged in therapy, I believe.
Yeah.
If she were to be released, she would go home to her husband, who helps care for her. They're both retired. I think Miss St. John did have a failure to appear. I think she had she didn't go to community corrections within a certain amount of time. From talks with her husband
and she went to community corrections, tested positive twice for cocaine use.
Yes. From the talks with her husband, apparently her memory from the Parkinson's is significantly affected. So knowing that moving forward, we'll make other efforts to get in touch with Miss St. John to remind her of everything she needs to do while out on bond.
Don't need a response with all of that, and considering everything, and defendant's continued use of narcotics in violation of bond. Motion for bond reduction denied. Bond will continue. Court calls case People versus, is it Micah Williams?
Hi. It's Micah.
Prosecuting attorney People. Carl on behalf of Ms. Williams. Ms. Williams, please state your name for the record.
Micah Williams.
Thank you.
Judge, today is the date and time set for probable cause conference. We are asking for an adjournment. The court should be in receipt of the green sheet.
Probable cause conference December 4th, 2025, 9 a.m.
December 4th, you said, Judge?
Yes.
Thank you.
Bond continued.
All right.
Thank you, Ms. Williams.
We'll be in touch.
Okay.
Court calls case People versus Procopio Vitale.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Vitale, who's here to my right.
Procopio Vitale. What are we doing?
Your Honor, we're seeking a very brief adjournment. Mr. Vitale has cleared the first hurdle to the drug court. They are coming, it's my understanding they're coming to interview him personally at the jail in the next few days.
Few days.
Yes. Yeah, I mean, they said this week, but it's a short week, so I would bet early next week, Judge.
You think everything will be accomplished by the 4th, or?
Maybe we should do the 11th just to be sure.
Be sure.
I think he sees Judge Slate for some reason, oddly on the 5th. I don't know why, but.
Okay. All right. I'll adjourn both of these to December 11th, 2025, 9 a.m.
Thank you, Your Honor.
Court calls case People versus Deveron Anderson.
Assistant Prosecuting Attorney for the People.
Okay, so Geos.
Sorry,
Yes.
Do we have the defendant in Zoom now?
Both of them.
Okay.
Your Honor, Assistant Public Defender Chelsea Vergils with and on behalf of Ron Anderson, please state your name.
DeVaron Anderson.
You're getting more and more like I can really.
I'm sorry, Your Honor.
Yeah.
Um,
Wow. Wow. What's wrong? I know, because she knows how much that would irritate. She's doing the right thing. She's good.
I'm doing my best, Your Honor. Thank you for your patience. In this case, we'd just like to set a preliminary exam.
Discovery is complete.
To the best of my knowledge, it is, Your Honor.
People have their witnesses available tonight.
I believe so.
Preliminary examination in person, December 9th, 2025 at 9 a.m. before Judge Washington. Bond will continue. Thank you.
Thank you, Your Honor.
Mr. Bowling and I approached on an urgent matter.
Yes, you're back.
You're all done. We'll see you very much.
Okie dokie. While they mute, let's head back to. Let's go Judge McNally.
So Detective Tulas, good morning. Are you on this case?
Yes, Your Honor.
You're the best at appearing. I'm going to give you a gold star when I see you next. You know that? On the PCCs and everything. All right. Ms. Patillo, can you hear me? Listen, she wants to set it for exam, so we have an exam date. I hate to keep the jail waiting, and she's obviously not in the council room, so I'm going to just go ahead, sir, and set this for December 2nd at 10:30 as it was set before.
Yeah, that's what she said she wanted to do anyways.
Okay, so that's what we'll do. We'll go to the exam next week. Do you have any questions? Talk to your lawyer if you have any questions, okay?
Okay.
Have a good day. Thank you.
Thank you too.
Thanks a lot, Detective. Warren Artherio Slappy Thrash, 25M608585. Did you guys resolve that? Am I going to look at that and have to quarrel with that? If I am.
I think you're gonna be very happy.
Good. Good. Do I have anybody here for Slappy Thrash?
Yes, sir. Yes, he's on Zoom.
Okay. How you doing, Mr. Slappy?
Pretty good. How about yourself?
Not too bad. Your name?
Warren Arterial Slappy Thrash.
Is Trooper Martin here? Thanks, Deputy. Trooper Martin here by chance?
Yes, sir.
Good morning, sir. Your name?
Trooper C. Martin, sir.
All right. Good morning to you, and good morning, Mr. Slappy. You're charged with 90 and a 70, 16 to 20 over. Do you care to offer anything here, Trooper?
I can give him 1 to 5 on the freeway if you'd like.
Listen, Mr. Slappy, can you listen to me, please?
Yes, sir.
They had you going back in February, 95 and a 70, and you outdid yourself in May by going 103 and a 70. Now, I don't know what you're doing. If you want to be a NASCAR driver, go into it. You can't be driving like a maniac down I-75 all the time. Why are you covering your mouth? You're going to laugh? I mean, I'm not trying to be funny here. I'm just telling you, you're driving like a maniac. Slow down.
I understand, sir.
Well, come on. I mean, come on. You're going to hurt yourself or somebody else. My Lord. I understand it happening. You just keep doing it. So you're good with 75 and a 70, Trooper?
That's up to you, sir. You have the final decision, but I'm good with that.
Well, I try not to get involved in their plea bargaining. What you guys offer or don't offer. Sometimes I'm not as good at that as I should be, but if you're good with it, I will do this. If you're not, just tell me. It's up to you.
Okay, that's good with me, sir.
You want to plead the 75 and a 70, Mr. Slappy Thrash?
Yes, sir.
I'm telling you, you come back in front of me, I'm not going to give you any breaks. Do we understand one another for speeding?
Yes, sir.
To the charge 75 and a 70, responsible or not responsible? Responsible, that's 0 points. It's gonna go on your traffic record, but it's 0 points. You understand that?
Yes, sir.
Okay. How do you plead the 75 and a 70, limited access?
Responsible?
I'll accept the plea. Dismiss the original charge. You're gonna pay 210 on this. You can pay that today?
Yes, sir.
Mr. Slappy Thrash, I hope you're taking me seriously.
Yes,
Right?
sir. Yes, sir. And I also want to thank the trooper.
Yeah, no, he's awful nice man.
Yes, sir.
He's doing that. A lot of them wouldn't have done that. Lisa, this commitment doesn't have a signature line. I'm just gonna sign at the bottom. They're not gonna reject that, right? I wouldn't think. If you think it's a problem, when you see it, let me know, okay?
Oh, yeah, I'm
Jason-
sorry. There was a page 2. It's on the printer.
No, that's all right. That's all right. Trooper, okay, you're all set, Mr. Slappy Thrash. Good luck. Make sure you pay that today. Jason Welton Cruz, 25 M612061. Ms. Patillo, I went ahead and just set that for exam. The jail wanted the defendant. It was already set for next week. So I just went on and told them December 2nd. It wasn't your fault. I didn't want to hold them up there, okay? Correct. 10:30, right, Lisa?
I
Thank
believe
you.
so. Yep.
Your name, sir?
Jason Cruz.
Trooper, your name?
Trooper Martin, sir.
All right, now. You gotta quit driving without insurance, son. I can take whatever you're asking me to do here. He's got, it looks like 3 moving violations in the past. If you want me to reduce it, he's charged with 92 and a 7.
No, I can't let, above 90 is pretty fast on the freeway there, sir.
Well, the other guy was going 92. I'm not, if you don't want to do, pardon?
No, did he have no insurance as well, correct?
No, this was just, I'm just saying he didn't have insurance on 3 other dates. He had, maybe he's only got 2 moving violations. He had no proof of insurance a couple of times in 24 and 21 and 20. But this one was not cited for no insurance.
Sir, is this Christopher Metzger James? I'm
This
not
is
sure. if this is
Jason
correct.
Welton Cruz. Jason Welton Cruz.
I'm not sure if I have that one, sir.
He's got a 2020 improper lane use, and besides the no proof of insurance, he's got a default judgment on a careless driving from 24 in the state of Kentucky. And other than that, just pretty much no proof of insurance. So I'm okay if you reduce it.
Okay.
If you want to.
All right. Yes, sir. I'm saying I'm not sure if this is my person. The other spin I have here is for Christopher James Metzger. Was I the OIC on this ticket?
You were on this one.
Okay. All right. This one I can do 1 to 5. I'll do the same thing as well
You
as
want to plead
previous
the
one.
75 and a 70?
Yes, sir.
You gonna slow down?
Yes, sir.
Slow down. To the charge, I mean, you guys gotta thank this guy. He's a nice man. To the charge, 75 and a 70, responsible or not responsible? Okay, I'll accept the plea.
Sorry.
Go ahead.
I just say sorry to the officer and you, judge.
You don't have to worry about me. I wasn't driving 100 miles an hour to catch up to you.
Yeah.
You don't have to say anything to me. You apologize. You're good. You're good. You're a nice young man. I'll accept the plea. Is that what you want me to do to 75 and a 70? Responsible? I'll accept the plea. 170. I gotta go a little higher. 180, okay? 180, please slow down, okay? Good luck. Where do you?
All right, everybody's still speeding in the Detroit area. Let's go back to Judge Simpson.
Where is it?
I would need to print it and get. Thank you.
Court calls the case People versus Rick Artuso.
Thorough Water Assistant Prosecutor Attorney for the People.
Assistant Public Defender Natalie. Who's approaching? Please say your name for the record, sir.
Rick Artuso?
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. We are respectfully requesting an adjournment. I did get some updated contact information from my client this morning.
Probable cause conference will be adjourned December 11th, 2025, 9 a.m. Bond continued. Thank you.
Very much, Your Honor.
Court calls case People versus Lorraine Atkins.
Brian Bowling on behalf of Mr. Atkins, Your Honor.
Larry,
just state your name.
dang, you know, I said last time, I said, I'm going to get it right. I'm going to get it right. I committed it to memory. I just left.
Larry Atkins.
I don't think that's his name. I'm going to sign an order changing it. That way I'll be right. All right.
Because we have a resolution, there's a plea form before you and also an assigned advice of rights.
All right. The plea form indicates that the defendant will be pleading guilty to the charge of false report of a misdemeanor to 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it. Is that correct, counsel?
That's correct.
May I have him sworn?
Right hand. Do you solemnly swear in the front of the testimony about to give the truth, the whole truth, and nothing but the truth? Okay.
Yes.
State your name.
Larry Atkins.
Sir, it is this court's understanding you're going to plead guilty to a misdemeanor charge of false report of a misdemeanor. That is itself a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that, sir?
Yes.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B district.
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Which one?
Probation.
You're on probation. Were you on probation at the time of this offense? No. All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will? And because you believe that you're guilty of this offense?
Yes.
On December 21st, 2023, at the location of 7080 Colchester, I guess, Lane, Ypsilanti Township, Washtenaw County, State of Michigan, what'd you do on that date that makes you think that you're guilty?
I phoned the police about some money missing from my bank account that I didn't realize I authorized to give out. I was inebriated at the time and didn't remember, but over time it came back to me that I did do that. And so
at the time you called the police, you did not know it to be false?
No, I did not.
And was there a point after you knew that to be false that you failed to notify the police of that?
I guess so, yes.
Well, I don't. Counsel approach, please.
Yes.
This one's a tricky one. We'll stay here while they speak at the bench. I want to remind you as you're out traveling this week that TCF is also a podcast. So if you want something to listen to while you're on the train, on the plane, in the backseat of the car, trying to sleep, whatever the case may be, although please don't sleep while you're listening to TCF. Maybe not that. But the rest of it, go get the podcast, available anywhere where you get your podcasts. We're pretty much out there everywhere. Download that thing, listen to it, enjoy court while you're out on the road. Also, again, a reminder, courtroomfiles.com. Black Friday sale going 15% off of everything for everybody. If you're a channel member, 25% off everything for everybody. That runs through next week, Monday, through Cyber Monday. So check that out. We've got some good holiday stuff there. A few more items will go up likely today or tomorrow for the holidays, and as well the TCF 2026 calendar themed Street Justice. I think you'll love it. Be sure to check that out. I feel like it's one of the best pieces of merchandise I've ever created for any of the businesses we run here at the bunker. So be sure to check that out. All right, let's go back to Judge. Hopefully he unmutes here in a moment and we can continue with this hearing. Or apparently they're discussing their Thanksgiving plans as well. We're slightly in the Wayback Machine. Let's try to nudge him forward slightly.
Your Honor
There we
should
go.
be in receipt of a green sheet. I have spoken to the people regarding this. We still do not have the 911 call or media discovery in this case. It has been requested by the people, so I'd request an adjournment.
And that's correct, Your Honor. We don't have the media either, so I couldn't.
Oh, you don't? Okay. December 11th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case of the people versus Moses Gunnigan Page.
Assistant Prosecuting Attorney.
Assistant Public Defender Chelsea Virgils with and on behalf of Moses Coonigan Page, who approaches. Please state your name.
Moses Cunningham Page.
Thank you.
Your Honor, we're asking for a brief adjournment in this case just to continue going over the discovery with our client.
Probable cause conference December 4th, 2025, 9 a.m. Bond continued. Thank you, sir.
Thank you.
Thank you, Your Honor.
Court calls case people versus Amiri Davis.
Assistant Prosecuting Attorney for the People.
Assistant Public Defender Sandra White on behalf of Davis, who I believe appears by Zoom.
Yes. Sir, state your name, please.
Amir Davis.
Your Honor, there has been an offer extended by the people. I need to discuss this with Mr. Davis, so I'm asking for an adjournment.
Probable cause conference will be adjourned December 4th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you, sir. Court calls case people versus Tegan Donald.
Assistant Public Defender Don Liba for Ms. Donald, who appears via Zoom. Ms. Donald, could you state your name, ma'am?
Tegan Summerstrader, Donna.
Thank you.
And I'm going to be requesting adjournment. Ms. Donald is presently hospitalized.
Okay.
I will be being released today, and I was asking if I should report to community corrections tomorrow.
Gotcha. Okay. So you're hoping to be released today?
That's the hope.
Okay. Understood. Probable cause conference will be adjourned December 11th, 2025, 9 a.m. Bond will continue. All right.
Thank you, Your Honor. And Ms. Donnell was inquiring whether she needs to report to community corrections upon her release.
She's not reported. Yes, she does.
Thank you, Ms. Donnell.
I haven't been able to.
Okay. All right. Thank you.
Thank you.
Thank you,
very
ma'am.
much,
Be
Your
well.
Honor.
Court calls case people versus Karen Skinner.
Mentor Water, Assistant Prosecuting Attorney for the People.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Ginyard. Thank you. Mr. Ginyard, state your name for the record, please.
Terrence Ginyard. Why is he wearing that M that I don't like right now?
It's nice color, I guess. He does work at U of M, Your Honor, so It might be part of his
So?
dress code.
So? Huh? He took it off? No, he didn't.
My apologies, Your Honor.
Okay, it was a bad weekend for me.
Yes, sir.
And you're just bringing it all up.
My apologies.
No, you don't care. All right.
So yeah, we are waiting on discovery. Spoke with people. I think it's on its way. There's also Mr. Ginyard also has to be arraigned on the count 1.
Yes, which counts?
It's amended count 1, yeah.
Didn't see this. What was it? Ah, okay. So as to count 1.
We'll waive formal reading, stand mute to the charge.
All right. Defendant arraigned on count 1. The court stood mute. Court will enter a not guilty plea.
And Your Honor, regarding the adjournment, Mr. Ginyard recently had a child. That child is in the NICU, and the child's not doing well. The status is kind of precarious. So he would like to request a bit of a longer adjournment.
Any objection from the people?
I wouldn't have an objection to a longer adjournment, however, bond violation may not be, because I just by email.
What is it?
I'm not in receipt of anything either.
Well, I'm in receipt of a report that indicates that as far as the SoberLink device that Mr. Ginyard is on, that he was late for a test on the 18th, tested negative. On the 20th, he missed a test, later tested negative. More concerning, on the 22nd, he missed a test, later tested positive with a BAC of 0.027, and then missed a retest at 12:19, 12:42, 1:19, 1:49, 2:19. Well, it says 2:19 twice. So there was a positive test and then several missed tests after that. People are concerned there was an open alcohol container in the vehicle when Mr. Ginyard was pulled over, and then later a firearm was found in the car as well, which is the basis of these charges. People have concerns about his alcohol use.
Well, Your Honor, I haven't spoken with Mr. Ginyard about the bond violation. I also haven't seen the discovery to respond to the allegation. I don't know why he's, yeah.
I'm sorry, sir.
I'm sorry, Your Honor. I haven't had any alcohol since I've been home. I have this tether on my leg. I've been doing this this silver leaf thing, and I haven't took any type of drug since I've been home. I've been working 6 days a week.
Mr. Ginyard, hold on 1 second, please.
He's going to need to get down here today because his Zoom privileges, had we had that, would have been revoked.
Okay, I'm going to call you, Mr. Ginyard, right now.
So I'll pass it, but I'll recall it sometime, likely around noon, but I've got some leeway this afternoon.
Okay.
All right. Thank you. Court calls case People versus Renee Hall.
Ashley Phelps for the people.
Your Honor, it's Warren Green on behalf of Ms. Hall. Ms. Hall, could you state your name for the court?
Renee Hall.
Thank you.
Your Honor, we're requesting an adjournment of this matter. We provided some documentation to the people. I'm asking for an adjournment to give them a chance to review that.
Tyranny, before you leave. What?
I'm asking for an adjournment so they can review the documentation we provided the people, Your Honor.
December 12th, or December 11th, excuse me, 2025.
Thank you, Your Honor.
9 a.m. bound, continue.
All right, he'll probably continue a few more bonds before his day is out and his day is done, but our day needs to be done. It is that time. I had fun today. This was better court than what I thought we would get the Tuesday before Thanksgiving. I hope that we have similar tomorrow, we're going to give it a try anyways. Normal time, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members, all that kind of stuff. If you're not a channel member, you should probably fix that. It's $2.99 a month. It is highly worth it. If you're considering anything from the store, do yourself a favor if you're not already, become a channel member first, because you will more than pay for it with the discount that you get. So make that happen. As I said a few minutes ago, TCF is a podcast as well. So while you're out and about traveling, download it. It'll keep you company while you're traveling and all that kind of stuff. Go have yourselves a great Tuesday. If you start your travels today, please be safe. If you start them tomorrow and I don't see you tomorrow, please be safe. Take care. God bless.